Weiss's Concise Trustee Handbook, a guide to the administration of an express trust under the common law, functioning under the general law merchant, by Carton Weiss, 2D edition, 2007. A guide to the administration of an express trust under the common law, functioning under the general law merchant, by Carton Weiss. Enlarged and revised copyright 2005 7 by Nax, all rights reserved. For private educational use only. This book is published with the understanding that the author and publisher, jointly and severally, are not engaged in rendering legal, accounting, or other professional advice. All decisions made based on the material in this book are ultimately done at the discretion of the reader. Author and publisher, jointly and severally, assume no liability whatever. Published by Negotiations Analysis and Contractual Relations Specialists, Nax, in care of Golder and Powers C. 1930 Village Center Circle, Suite 3 213 Las Vegas, Nevada, 89134. Email, contact us at nax.org. Telephone, 70235788830. http://www.nax.org. Introduction. This handbook is about the administration of express trusts created under the original American common law and functioning within the unique system of commerce in the American states, that is, the general law merchant, 1 as it stands in 21st century America. The material presented herein has been reduced from various sources which the reader is encouraged to examine for his own knowledge and further understanding. The material herein has been rendered into a concise handbook format, intended to allow the reader to refer to each section for guidance on decisions regarding the most pertinent aspects of the administration of an express trust. So, only secondary attention has been given to all other matters. All in all, the author's objective by this handbook is to devise a simple guide, with clearly outlined methods and sample forms, for the effective handling of affairs of express trusts, while also showing the many options for growth and prosperity, and profound protections afforded by express trusts when created and administered properly. This book is written in a somewhat unconventional manner in order to accommodate this objective. If the reader should find, after examining the sources, that this work has failed in its objective, then let it be attributed to a fault of the author, not to any supposed faultiness of the sources or the express trust itself. It will be admitted by all honest and learned lawyers, as it once was when a lawyer, by definition, was learned in the law 3, that the express trust, especially one created with proper care to its instruments, is a far superior form of security, or organization in general, for individuals who desire to exercise their natural rights. Trust Basics. First, it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. For the classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of a party or by operation of the law. In the case of the former, trusts are divided into two types, express or implied. Without getting into the various subclasses of express and implied trusts, the basic difference between one created by express act of a party and one created by implied act of a party is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. These are very generalized definitions, so presented for want of space. Since there are many intricacies concerning the true meaning of the term implied, it has been shown that, in a sense, the classification of express trust can only be applied based on what is implied by the language of the instrument which created the trust. 5. So, we won't get into that. Our focus is on a particular written express trust type, and even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protections of the common law. Express trusts under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise definition by Alfred D. Chandler, Esquire. 6 In a report submitted to the tax commissioners of Massachusetts on unincorporated associations. 7 His study was conducted as part of a legislative investigation into their economic effect on the state in 1911. In the first part of the report, at pages 6-7, he offers the following definition. Express trusts. Put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of same, but are neither partners nor agents. This simple, adequate, common law right, any person or group of persons sui juris may exercise, the trustees issuing certificates of beneficial, and capital, interest divided into shares, as well as issuing bonds and other obligations, as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. Italics emphasis supplied in original, bold emphasis and bracket information added. What becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another like any basic trust. Rather, it is a trust created by private contract for the holding of a divisible property interest wherein the trustee is empowered by the settlor to do for a beneficiary of his, the trustees, choosing whatever he may do for himself as an individual sui juris. 9 What has been created here is a trust organization, lawfully, by natural right. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself he may authorize another to do for him. 10 Doing so requires no benefit, privilege or franchise from any government or other outside party. 11 And, therefore the parties owe no duty to any government or other outside party to the extent that no common law criminal or civil wrong is the purpose of the contract. 12 When done properly the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. 13 Now, the question is whether the parties to the contract are truly acting sui juris, that is, of their pure, unadulterated common law, natural, rights, because if the parties import or associate benefits which grant an outside party a vested interest in the proposed contract, then the contract has acquired a third-party overseer/intervener. 14. Declaration of the express trust. The declaration of trust. 15 is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the words used make clear the settler's intent to create the trust or confer a benefit of some sort that would be best carried out in the form of a trust. 16 A trust instrument doesn't necessarily need to be a declaration either, for a trust may be, and often is, formed out of a simple agreement or even a will. 17 But with an express trust, the declaration has been preferred since the beginnings of trusts under the common law of England, which otherwise shunned fictions of law. This is where careful attention to detail is most crucial, because in order to properly construe the intent of the settlor, the objects, property, and manner in which all is to be carried out must be set forth in unambiguous, precise language so as to particularly create the express trust, and where the intent of the settlor is unclear, under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid, depending on the degree of ambiguity. 18 However, when all is done properly, obviously, there can be no lawful impairment of the obligations of contract. 19 Moreover, the declaration, by its terms and provisions, serves to establish the entire contractual arrangement, including the identities and positions of the parties, the trust's name, jurisdiction and situs, and all particulars of administration, all of which the courts of equity will fully support by the principle that equity compels performance. 20 The ultimate result is the creation of a bona fide legal entity. 21 With its own separate and distinct juridical personality. 22 With standing to sue and be sued. 23 And to function as a person in commerce by and through its trustees. The term natural person has been applied to express trusts by courts of equity because of its administration being carried out by men acting as natural persons. 24 Under this application, the trust's right of contract is alienable, whereas its creator's natural right of contract obviously is not. 25 The express trust nevertheless possesses, inter alia, the right to all enjoyments stemming from the contracts into which it enters, as well as all the obligations imposed under such contracts. The express trust possesses the ability to hold, own property, engage in business transactions, and incur liabilities, including tax liabilities, as well as assume creditorship, including secured party status, like any other legal person. The Trust Corpus. The corpus is the body of the trust, that is, the property being held in trust for the beneficiaries, the very subject matter of the declaration. It should be noted that virtually anything 26 may be held in trust. However, there are certain things which, given their innate traits recognized in law, make for better subject matter, so to speak. Initially, the legal minds who perfected the express trust in America did so to accommodate for the great obstacles in procuring special charters for corporations intended to deal in real estate, which trusts eventually came to be known as the Massachusetts Land Trusts. It was when those individuals came to realize the immense benefits of employing the trusts for the purpose of holding land, that they eventually expanded their utility to include the holding of personal property. These eventually came to be known as the Massachusetts Electric Companies. As an aside, when considering the presently hostile official attitude toward non-statutory trusts, what is interesting to note is that much of the express trust's perfection is attributed to Attorney General and later United States Secretary of State Richard Olney (27). But the fact that the express trusts were initially, primarily utilized for purposes of holding and handling real estate is very significant, especially to our present situation. The significance derives, in pertinent part, from the integral relationship between the law and the land. It is a fundamental principle of law that the land and the law go hand in hand, and, in America, without the 14th Amendment, the law of the land is the Constitution with its common law principles and its substance of gold and silver. 28 Referred to in this sense, precious metals are regarded in law as portable land. The basic principle of law holds that land includes everything of value extracted from it, and without getting too deep into the operation of common law, it is this principle regarding the relationship of land and law which, by its operation, threw up an obstacle to corporate real estate ownership. In order to charter a statutory, civil law, entity to handle the substance of the common law, land, special, if not extraordinary, legal circumstances must exist. These circumstances did not exist prior to the posterior Federal Common Law 29, whose imposition was made possible by loss of the gold standard, the substance of the law. In 1933.30, a statutory entity is inherently accountable to courts of civil, legislative, jurisdiction, deriving subject matter jurisdiction from the corporate charter, over which the legislature holds in rem jurisdiction as well by way of possession of the charter documents themselves. Whereas, an express trust is obviously inherently accountable to courts of common law and equity. 31 Deriving subject matter jurisdiction from the trust instrument and corpus. As logic follows, in rem jurisdiction remains with the trustee at all times unless the trust instrument and corpus are surrendered to a third party voluntarily. In rem jurisdiction, that is, actual possession, is the key. This brings us to today. In the jurisdiction of the 14th Amendment United States Public Trust, precious metal, the substance of the common law, is legally merely a commodity. Back in the Republic, however, it remains the staple for payment of debts. 32 Though surface gold and silver are in considerably lesser quantity and without a fixed standard upon which to be traded, the express trust under the common law, holding real estate, silver or gold, is holding the very substance of the law under which it was created, thus ensuring that bond between law and land, and the powers and guarantees that come with it. 33. Certificates. What may come as a surprise is that any trust may divide its trust property into shares and issue certificates. 34 The power to issue certificates and bonds, and employ the use of an official seal. 35 Never has been restricted to corporations. 36 It is well settled law that whatever else most corporations possess beyond their artificiality and right of suit in a corporate name is a mere incident or consequence of incorporation, and not a primary constituent. 37 In fact, most attributes now commonly held as corporate in nature, such as the power of issuing transferable shares, limiting liability of officers, using an official seal, making bylaws, purchasing lands and chattels, are merely the legislative recognition and adoption of natural common law rights any man or woman sui juris may exercise without permission, much less a charter, from the state. The court in Warner v. Beers 38 clarified this principle most effectively. There are several very useful and beneficial accessory, also spelled accessory, powers or attributes, very often accompanying corporate privileges, especially in moneyed corporations, which, in the existing state of our law, as modified by statutes, are more prominent in the public eye, and perhaps sometimes in the view of our courts and legislatures, 39, than those which are essential to the being of a corporation. Such added powers, however valuable, are merely accessory. They do not in themselves alone confirm a corporate character, and may be enjoyed by unincorporated individuals. Such a power is the transferability of shares. Such, too, is the limited responsibility, liability. So, too, the convenience of holding real estate for the common purposes, exempt from the legal inconvenience of joint tenancy or tenancy in common. Again, there is the continuance of the joint property for the benefit and preservation of the common fund, indissoluble by death or legal disability of any partner. Every one of these attributes or powers, though commonly falling within our notions of a moneyed corporation, is quite unessential to the legality of a corporation, may be found where there is no pretense of a body corporate, nor will they make one if all were combined, without the presence of the essential quality of legal individuality, italics and bold emphasis, and bracket information added. The trustee of an express trust is empowered by the terms and provisions of the trust instrument to issue certificates not only of beneficial interest, 40, but also of capital interest. 41 Generally speaking, beneficial interest is that which is held by the beneficiaries of the trust, who is entitled to a certain proportional share of the trust assets during the life or at the termination of the trust, while capital interest is that which is held by the exchangers who has invested property into the trust, and thus becomes entitled to a certain proportional share of any profits and assets remaining at the termination of the trust. As a rule, the terms and provisions of the trust instrument control the manner in which beneficial and capital interest are to be administered. It should define the rights of interest holders, who, incidental to their acceptance of the interest, are bound under the trust instrument to that extent. 42 But there are certain principles which govern these interests in construing the fundamental classification of the trust. For instance, it is held that where the certificate holders have control over the trust property and or administration of the trust's affairs, the trust arrangement is, in fact, a partnership, in which the shareholders become liable for the acts of the trust. 43 The basic principle is that if it is free from the control of its interest holders, then it is an express trust. 44 This is commonly referred to by courts of equity as the control test, 45 in which, control must ultimately rest with the trustees of the trust in order for it to be properly classified as an express trust. The well-settled principle applied by courts of equity is that interest holders, by full legal title and control over the trust property being vested absolutely in the trustees, cannot be considered partners nor agents, 46 and therefore cannot be held liable for the debts of the trust in that manner. 47 Furthermore, the certificates have no determinable fair market value, and, therefore, no gain or loss is recognized until the cost or other basis of the property disposed of has been recovered. 48 In Commissioner of Internal Revenue v. Marshman, 49 the court held that fair market value is determined by property received by the taxpayer, not the fair market value of the property transferred by the taxpayer into the trust. What's more is that certificates are considered not necessarily as chattels, but as documentary evidence of ownership and intangible rights. 50 And of themselves, they are only personal property. 51 Not the actual interest or share itself. 52 The interest in an express trust cannot be traded without the approval of the trustees. This is contrasted with the certificate of stock, which courts have long held may be dealt with in the market as a commercial document of value. 53. Trustee Basics. First and foremost, anyone, man or person, capable of taking physical possession of or legal title to property can be a trustee. 54 And there is no limit to the number of trustees who may serve in any one trust. Generally, where there is more than one trustee, the trustees, with respect to each other, are referred to as co-trustees. 55 And when acting jointly as a collective body are referred to as the Board of Trustees. Furthermore, there is no law prescribing the character of a trustee, and while it has been held that a trust cannot be invalidated simply due to incompetence, the trustee should be at least someone capable and fit for executing the powers and duties honorably. 56 This is the basis for the general rule that beneficiaries are not desirable as trustees, though there is no law to forbid such appointment. Equity will generally avoid all temptation to a breach of trust. The trustee should be stationed within the jurisdiction of the court of equity in which the estate is located, if indeed the trust corpus is an estate. But where the trust corpus is portable land, the trustee need not be stationed within any single jurisdiction. Non-residency will not disqualify or preclude the trustee from carrying out his position. 57 As far as accepting the appointment is concerned, this should be done formally, expressly in writing, even though it will always be implied if the individual intermeddles with the trust property, or performs any act to carry out the trust. 58 Once acceptance has been tendered, no court of common law or equity can prevent the trustee from holding that office, except for breach of trust. 59 Or good cause dependent upon clear and lawful necessity. 60 Removal must be procured pursuant to the provisions of the declaration, or, where no such provisions are made, by decree of a court of equity. Lastly, it should be noted that the office of trustee is not always a desirable one. When the trust instrument conveys a burdensome obligation, the trustee is miserable and at risk of breach by failure to perform. When the trust instrument has been constructed poorly, the trustee is miserably confined and inhibited, and he may well be held liable for trust contracts with outside parties. The trustee has a duty of care toward the beneficiaries, and must harbor no biases or resentment in administration. Therefore, it is prudent to empower the trustee with enough discretion to carry out his position to the best of his ability and responsible creativity. To put it plainly, the settlor must truly trust the trustee to carry out his duties, and use his powers justly. Powers and duties of the trustee. The powers of a trustee are divided into three categories: general, special and discretionary. The general are all those inherent in trustees' virtute officii, that is, ordinarily conferred by trust law. The special are all those conferred by the trust instrument, and the discretionary are all those arising out of the necessity of personal judgment, though broad discretion may also be conferred by law and as well as by trust instrument. 61 It is well settled law that under a declaration of trust, the trustees must have all the powers necessary to carry out the obligation of that private contract which they have assumed. 62 Furthermore, it is settled that the trustees of an express trust are afforded greater latitude to carry out their duties than ordinary trustees. 63 The trustees are empowered to control every aspect of the trust according to the trust instrument and equity, and retain the power to remove even the beneficiaries from the premises. 64 These powers include, but are in no way limited to: the power to bind the trust in a contract, especially where such obligation is implied by law. 65 And the power to contract with the beneficiaries. The power to partition, exchange, sell, pledge or mortgage the trust property, either in whole or in part. 66 years the power to lease trust property. 67 years the power to issue, change, or otherwise dispose of securities of the trust. The power to support the beneficiaries in all reasonable manner. The power to prosecute and defend in the trust's name or trustee's name. The power to make gifts out of trust property. The power to delegate all unessential powers and duties, and the power to exercise personal judgment and every discretionary power not prohibited by the trust instrument. 68 He may do whatever a man or woman may lawfully do according to natural right. The fundamental principle of law is that for every power there is a correlative duty. The trustee, as a fiduciary to the beneficiaries, assumes certain basic duties outside of the management of trust property, and other general duties aside from whatever specific duties may be conferred upon the trustee in the trust instrument. These duties include but are not limited to, the duty to support the beneficiaries in any essential needs which it may have, out of the funds which would otherwise be paid to it in distribution. And if such funds are not available, the duty to accumulate any balance needed. 69 years. The duty to refrain from taking advantage of peculiar knowledge or position when dealing directly with the beneficiaries. The duty to exercise the utmost good faith in all concerns of the trust, whether dealing with the trust property itself, or directly with the beneficiaries in matters concerning the trust. 70 including to care for, protect and secure trust property. The duty to preserve, protect and further the trust's interests according to the purposes designated in the trust instrument, including pressing all reasonable demands and prosecuting and fending off all claims, and claiming all available exceptions and taking all available remedies and advantages in trust matters. When delegating unessential powers and duties, the duty to exercise at least a general supervision of the trust affairs, and to perform any ministerial acts which require the exercise of discretion or judgment. 71. The duty to keep minutes, and separate accounts of the trust, even if kept in a book with other accounts, with minutes showing decisions and resolutions reached, and accounts showing the state of the trust and pertinent details of transactions, generally in the form of schedules of income received, income paid, additions to principal, deductions from principal, principal on hand, and changes in investment consisting of debtor and creditor sides. 72. Upon acceptance of the trusteeship, the duty to secure and protect the trust property and trust documents. 73. When investing trust funds, the duty to invest them securely, so that they shall be preserved intact for the remainderman, and to invest productively, so that they shall yield, at least, the current rate of interest to the life tenant. 74. And the duty to concur with all co-trustees, except where authorized to act individually. 75. Privileges and liabilities of the trustee. In addition to powers and duties, there are certain privileges, including allowances, rights and liabilities of the trustee. These are all those which are enumerated in the trust instrument and naturally extended to the trustee of an express trust. As was noted earlier, certain restrictions placed upon trustees of ordinary trusts do not apply to the trustee of an express trust pursuant to the doctrine of greater latitude. 76. These, aside from those allowed by the trust instrument, include, but are not limited to, the inherent, unquestionable right to full compensation, including reimbursement of all out-of-pocket and other expenses incurred in the discharge of duties, and unduly withheld reimbursement results in a lien on the trust for the amount plus interest. 77. The privilege of residing within the trust estate and allowance of rates and taxes although he, the trustee, has the benefit of residing in the house. 78. The right to employ a solicitor. 79. For assistance and guidance in the administration of the trust, and, in the case of any doubt or difficulty, to seek the opinion of competent counsel, and, in the case where the trust's accounts are intricate and complicated, to seek the assistance of an accountant, to the charge of the trust. The right to apply to a court of equity for directions in the execution of the trust, or to obtain a declaratory judgment in order to establish the meaning and intent of the trust instrument. 80. The right to carry on in separate business for the benefit of the trust given certain conditions, the allowance of remuneration for loss of time under certain circumstances. The right not to be compelled by subpoena or review to produce and show records or books to outside parties. 81. The right to further limit his liability in particular contracts, even beyond the limitation made in the trust instrument, the right to relocate, move trust property, or change the trust's domicile. 82. And, the inalienable right to disclaim the office at the execution, or resign at a later date. With regard to the personal liabilities of a trustee, basically, the inherent liabilities, and non-liabilities, are all those incident to ownership at law. 83. And imposed or exempted under contract law, for it is a maxim of law, le contract fait la loi. 84. Therefore, a trustee's liability is largely determined according to the particular circumstances of the situation, especially contracts wherein the trustee has properly limited his liability via qualified signature. I will discuss the principles of and procedure for properly qualifying one's signature in a later section. For now we will entertain the general liabilities, which may include, but are not limited to, liability on all contracts made, whether signing as trustee or signing individually. 85. Liability of removal for breach of trust, waste, mismanagement, or good cause shown in an action for removal in a court of equity. 86 or according to trust instrument. Liability for losses sustained by the trust as a result of negligence. 87. Liability for torts and common law criminal and civil wrongs, or acts of bad faith. 88. Liability in all cases of commingling of trust funds. 89. And liability for all mischief of his agents contracted to exercise discretionary powers. 90. But the trustee is not at all liable for any losses sustained in the proper discharge of duties. 91. And, in the case of other losses due to negligence or tort, the trustee may be able to be bonded in the manner ordinarily used by executors and administrators. They are generally not liable for contracts in which liability was properly limited using the methods to be shown later. Such contracts may also encompass the codes and statutes of various jurisdictions, given that all man-made law is, by its nature, fundamentally contractual. The debts of the trust incurred requiring the creditor to look solely to the trust for payment. 92. Conversely, the trust is not liable for the personal debts of the trustee either. 93 except to the extent of attachability of the trustee's interest in the trust. 94. The independent, non-preventable acts of co-trustees, of which he had no prior knowledge. 95. The acts of his agents when properly contracted, taxes on income of the trust. 96 and lawsuits against the trust. Authorized representatives. As shown above, it is well within the power, discretion, and, oftentimes, duty to contract an authorized representative, managing agent or attorney in fact to deal with certain affairs of the trust. And the basic rule which courts of equity have laid down is that a trustee may contract such agents to handle all affairs which require no discretion, be they ministerial or not, and he may not delegate the essential part of a power unless, of course, he is permitted to do so by the trust instrument. 97. In clarifying the discretionary power rule, it must be noted that there is no law against delegating discretionary powers to agents. The rule is simply that a trustee who does so at his own peril. 98. For he is liable for all losses generated by the agent, if any. To clarify what constitutes the essential and unessential parts of a power, the essential part is defined as the exercise of discretion, the determining of needs of the trust, or the appropriateness of an action. The unessential part is that not requiring the exercise of discretion, etc., etc. However, there is a simple solution, allowing for greater flexibility in this rule. The solution is to authorize the agent to contract, on behalf of the trust, subject to the assent of the trustee. 99 And, as noted in the previous section, if the trust instrument makes provisions for the contracting of an authorized representative, then the trustee cannot be liable for his acts. 100. Now, the method for contracting such agents may be either by formal appointment if mandated by the trust instrument, or by execution of a limited power of attorney, letter of authorization or even certificate of verbal authorization documented by minutes of meeting. The most effective, secure method of contracting such an agent would obviously be an actual appointment with written contract setting forth the specifics of the position. But, our letter of introduction is, for most purposes, sufficient, as is a simple power of attorney when the agent is acting specifically under the title of attorney in fact. 101. Express trust versus corporation. First, I must clarify, though I am referring primarily to corporations, included in the reference are all organizations which owe their existence to legislative acts, not limited to limited liability companies, limited partnerships, agencies, associations, etc. Though not classified as corporations, they avail themselves of benefits, privileges, and franchises of the state for their very creation and existence. Second, Since we have already shown the distinct juridical personality of the trust as a legal entity, 102, we will not re-examine it until we consider its personality under the Roman civil law of the 14th Amendment in a later section. But it must be noted the well-settled law that the express trust is a lawful, 103, legal, valid business organization, 104, with the right to hold property and sue in its business name. 105, and its uses in modern business have some of their strongest roots in England, Germany and many of the United States, where it has been recognized for its superiority, and even praised, by such notable authorities as the Ohio Supreme Court for its effectiveness in the business of life insurance. 106. The declaration of trust has been held to be an effective substitute for incorporation, for its many advantages, which will undoubtedly shine through to the reader by the following table. I have prepared this table based upon the work by John H. Sears, who, after discussing the impact of the twin landmark cases 107 on the grave lack of profitability of using corporations for, inter alia, dealing in real estate, went to task in outlining the distinct benefits of express trusts. The works by William C. Dunn, 108, Guy A. Thompson, 109, and Sidney R. Wrightington, 110, are cited as well. Mr. Sears says, 111, the decision of the United States Supreme Court, holding that their express trusts are not subject to the federal excise tax on corporations, has emphasized this method of conducting business as compared with corporations. His best legal talent was soon impressed into the service of devising a means of affording the usual advantages belonging to a corporation without the authority of any legislative act. A method of placing the property into the hands of trustees, who held the legal title and issued certificates, similar to shares of stock, to the Cestui Que Trust, showing the interest owned by each, possessed nearly all the advantages desired. This excluded the use of limited liability companies, joint stock associations, and co-partnerships, which are organized under enabling statutes which merely enlarge the privileges possessed at common law, and they are, therefore, subject to state regulations, which may be equally burdensome to those imposed on corporations. Italics emphasis supplied in original, bold emphasis and bracket information added, governed under equity. Trust law is the most well-settled body of law in America. Corporation express trust governed under statute, forever changing according to political agendas and schemes. Trustees are sole authority, except where delegated to agents or a board of directors. Board of directors are managers with limited, defined powers to conduct business, hold regular meetings, etc. Trustees afforded more leverage and powers are generally broader than corporate officers. Law provides that whatever any individual may lawfully do, the trust can do. The sky, nature, is the limit. Relatively broad powers, such as withholding companies. But corporation may not do whatever any individual may lawfully do, they can only do what is legal. The statute, legislature, is the limit. Trustees' liability is limited by trust instrument and by signature on all contracts and instruments. Remember Boyd and Silverthorne. Trustees not subject to subpoena. Corporate officers personally liable to legislature and to creditors for all ambiguous endorsements. Remember Enron and Global Crossing, cannot escape service of process. 112. Lifespan of 20-25 years at a time in order to avoid rules against perpetuities. Death of settlor or trustee has no effect on life or affairs of trust. Succession of power is quiet and private. Lifespan is perpetual or certain number of years according legislative requirements. All officer changes must be reported, which records are open for public review. Trust is not required to obtain business license. 113. The opposite is the case. Trustees are not required to file reports with any entity, and are accountable only to the beneficiary, governed strictly under principles of equity, required to file statements and reports quarterly, etc. Business name is naturally protected by injunction, may also use trade name or trademark for trust purposes without registration. 114. Must apply for and secure fictitious firm name, and must register all trade names and trademarks. All federal excise tax and state organization and franchise taxes are legally avoided. The opposite is the case, except for state taxes in certain states. In either respect, all corporations are taxed indirectly via inflation. 115 Not subject to foreign corporation laws of any state. Not inherently subject to commercial regulation except for income derived from corporate stock and physical franchises under Article I Section 8 Clauses 1 and 3. Express trust is a valid legal entity in all states of the Union. 116 Inherently subject to all foreign corporation laws and public policy regulation. Trust may function as an Article 4 Section 2 citizen of the United States via its trustee, not a 14th Amendment citizen. 117 This citizen is understood in constitutional law as the private citizen. 118 Corporation is 14th Amendment citizen, 119 regardless of citizenship of corporate officer. Generally state corporations require officers to be citizens as well. This citizen is inherently public due to the nature of the amendment. 120 Trustees have absolute rights and privileges to engage in commerce under protection of the federal Constitution. 121 Corporate officers have relative right and privileges to do so, and incur more taxability by doing so. Trustees issue certificates in the manner prescribed by trust instrument. Certificate holders have no say in the administration of trust affairs. Must go public in order to issue stock. Stockholders have a relative say in affairs depending on the extent of their holdings. Interests of the beneficiaries well protected by equity. Power to secure information as to the actions of the trustees and trust affairs is, no doubt, superior to the rights and remedies of stockholders in corporation. Stockholders' rights protected by courts, yet the basic statutory nature of corporations allows for abuse. Stockholders are generally at the mercy of someone. Units of interest in the trust are not personal property of certificate holder and carry no liability as such. Shares of stock are personal property in hands of owner, and taxes issue on same property against both owner and corporation. No legal obligation to maintain the capital and refrain from paying dividends out of capital. Trust instrument governs. The opposite is the case. May prosecute, defend litigation in trust or trustee name without compromising legality. Same rules as to parties and procedure at law and in equity are applicable. May bring and defend litigation in the corporate name and entity only. The process of piercing corporate veils succeeds mostly due to confusion of personal and official capacities by officers. While the mortality rate of corporations and the like have historically remained high, express trusts remained, and indeed to this day, continue to remain vital. 122 Also, as the table shows, many of the powers of an express trust are substantially the same as those of a corporation in effect, but without the legislative requirement of registration in order for those powers to be activated. These advantages and more have been and are still seized by some of the shrewdest, wealthiest individuals and families in America and from abroad. But the widely perceived, yet untraceable, wealth of such individuals and families like the Rothschilds, Rockefellers, Kennedys, Forbes, and many of the American founding fathers, plus countless modern-day politicians, are strong circumstantial evidence of this. One may find many articles and information, as well as quotes, 123 attesting to this. Lastly, it should be mentioned that, unlike the corporation, there is no lawful method by which to pierce the trust without the express permission or implied consent of the trustee, or some unlawful activity on the part of the trust giving rise to a bona fide cause of action. As a result, virtually no direct evidence of the trust's existence can be found unless it is made to be found via recording. Even then it can only be heard by a court of competent jurisdiction, which, as you shall see in the sections ahead, is very hard to find nowadays. This is protection at its finest, hiding in plain sight, for as the maxim goes, bene vixit, qui bene latuit. 124 Understanding commerce. Here is where we begin to address the express trust in action. As shown above, the trust may engage in all manner of trade and commerce, 125 but before taking the step of doing so, The reader would greatly benefit the trust by understanding the nature of commerce in 21st century America, and for my brief explanation of the subtle intricacies involved, I will rely upon the two works by Lieberobst et al. 126. I will not go into a detailed explanation of the Constitution or the history of commerce for want of space, but I would suggest that the reader read the works relied upon herein. When the trustee is engaging in trade or commerce in behalf of the trust, acting under general common law, the trust is within the jurisdiction over which the literal and absolute protections of the Bill of Rights extend, and he has no direct contact with the federal government. Under right of contract law protected by the federal Constitution, the trustee may enter into the 14th Amendment jurisdiction via contract, that is, by willfully availing the trust of benefits like the quasi-corporate privilege, franchise of limited liability for the discharge of debts using Federal Reserve notes, pursuant to the economic system established under former H.J. Rees. 192.127, contrast discharge with the payment of debts with standard gold-backed currency under the original Coinage Act of 1792. Under this jurisdiction, the federal government, Congress, has full and direct contact with the trust, as they see fit, for the benefit of public policy regulations, known as codes and statutes, of this jurisdiction. 128. This makes the federal government a third-party intervener in the affairs of the trust by operation of law. 129. Because the trust, as with the 14th Amendment citizens, is being allowed to get away with not truly fulfilling its commercial contracts as is required under the common law of contracts. I will show how this can all be avoided, in a later section. The resulting nexus or confederacy developed under H.J. Rees. 192. Is an affiliation known better as an association. 130. And the common enterprise of this unincorporated society is to offer all Americans a so-called privilege in the form of what is better known as a quasi-contract, to participate in commerce without payment of debts for Social Security purposes. Moreover, this unincorporated society is outside the literal common law principle that demands the payment of debts as stated in Article 1 Section 10, but is allowed, upheld and protected by Article 1 Section 10 that upholds their obligation of contracts. 131. This amounts to a federated unincorporated society by operation of law, which is contractually protected by the Constitution, in the same way the express trust and its trustees are. And the trust and or trustee reserves the right to domicile themselves in the Union under Article 4 Section 3, see Laws 1, and, thus to contract under Article I Section 10 despite the fact that they cannot pay their debts. In other words, Congress cannot compel the trust or its trustees to participate in a federal interstate unincorporated banking association under Article 4 Section 3, see Laws 2 and H.J. Rees. 192. For the non-payment of debts, the choice of law is up to each person still. 132. Corporations are artificial creations of the state or federal government under physical charter, franchise, issued via state or federal civil law for commercial regulation under Article I Section 8, see Laws 1 and 3. They are not under the literal common law because of the charter, franchise. Any legal action against the corporation is legally called an in rem action, because it is against the thing or property, also called res, of the corporation under charter. The courts have automatic subject matter jurisdiction, because the physical charter is the subject matter. 133. Under the letter of the constitutional law there is no commercial regulation, but H.J. Rees. 192. Along with 15 U.S.C. brought in a third party for commercial regulation for the Social Security public policy. Remember, equity compels performance. The law views unincorporated associations as a danger to the substance of the common law, because of their debt credit system. This is because there is no counterbalance to the demands the association puts on the substance of the earth. Thus the reason for all the federal and state regulatory agencies. In other words, There is a presumption by implication in the civil law that a charter, a metaphysical/abstract/unreal type, exists, because persons are availing themselves, volunteering, of the privileges pertaining to H.J. Rees. 192. Therefore, these persons come under a quasi-in rem jurisdiction of the civil law in order to regulate, control, including compel, those that are outside the literal common law principles. 134. The many participants under this system, especially the 14th Amendment citizens from each state, together form an unincorporated federation of state associations operating under interstate commerce as addressed in Article 4 Section 3 centiliters. 2, and reinforced by the landmark Erie Company v. Tompkins 135 decision. This is the basis for the federal and state government's compulsion of persons to its private international law, that is, the spirit, not the letter, of the common law mixed with public Roman civil law, under law of nations per Article I Section 8 CLS 3 and 10, and Article V CL 2, nowadays commonly known as codes and statutes, state or federal, to regulate everything as a matter of commerce. 136. Without getting into the history of religion, and speaking purely from an analytical perspective, the Roman civil law, as a base model for commerce regulation, was developed out of necessity of the Church to avoid political scrutiny for its handling of ever-increasing amounts of precious metals. It had become a storehouse for the money and property the people were persuaded to give in exchange for limited liability, go directly to heaven instead of hell. As the people became more educated and saw what was really behind the power of religion, in generating wealth, the Roman Church fell under greater and greater criticism. This led to the development of a banking system to handle and control church wealth and take the critical focus away from the church. 137. The bank learned from the church about limited liability. If you could get people to borrow money beyond their ability to pay back, you could get them to keep performing, paying interest in one form or another, on a debt, liability, without ever demanding it, the principal, back, thereby loaning out that same credit to more than one individual or company. This meant that the bank was limiting the liability of the borrower, so he was not fully responsible for the debt as long as he continued to perform to paying the interest. This way real money, gold, became credit, paper money, by loaning to more than one person. Being involved in this sort of commerce was called private commerce. With the church's control over wealth, this private commerce became standard practice in world trade upon the sea. Private international or admiralty, maritime law became known as Roman civil law as it began to figure heavily in the politics of every city and country it touched through international commerce. 138. By operation of this body of law, particularly its in rem element, all persons subject to its jurisdiction are not necessarily regarded as fictional vessels per se, but are more so as objects of the state, discussed earlier, see footnote 24. These objects, like vessels in traditional admiralty practice, are vested with a distinct quasi-corporate, juridical personality, but, unlike vessels, are capable of suing and being sued in personam. 139 14th Amendment citizens of the United States, whether state or federal chartered corporations or metaphysical chartered corporate colored public persons, therefore, are akin to public vessels of the United States within the broad meaning of the Public Vessels Act, and are regulated accordingly. The United States, as with the Roman Church, is considered in international law as a ship of state. The express trust, then, is akin to a private vessel of the United States of America, navigating through the often hostile waters called interstate commerce, which is international commerce via the United States treaties. Doing business. Even though the express trust is technically not a business trust 140 within the established meaning of the term, this in no way prevents or inhibits the trust from engaging in all manner of business the trustee is permitted to under declaration, and it need only obtain the franchise of a business license if it anticipates doing express business in the above described jurisdiction. 141 The trust may operate a business, acquire a business, sell or otherwise dispose of its business, or even contract under the limited liability system and become a taxable entity, The choice is yours. The only thing which may bar the trust from conducting a particular kind of business in any certain jurisdiction is the public policy of that jurisdiction, regarding which, it has been admitted, most states have not passed upon the subject directly. 142. Regardless of the nature of the business, there is a due notice rule which confers a duty upon the trustee under equity. The rule consists of two parts. The first is that he should sufficiently distinguish and represent the nature of the trust to the party with whom he is doing business. It is of the utmost importance, in the forming of business contracts, that full disclosure be made, on all letterheads, business cards, checks, bills and order blanks, papers, etc., so as to prevent any claims of lack of disclosure from arising in the future. But prudence dictates that a trustee must not disclose every fact regarding the trust, its declaration, and its affairs. The first part of the due notice requirement can be sufficiently accomplished simply by employing the designations irrevocable express trust organization, express trust organization, trust organization, or organized under declaration of trust, beneath or next to the trust's name. It must not be excessively revealing about the trust. The trustee has a duty to protect the privacy of the trust, but it also must not be misleading. The trustee has a duty to not compromise the integrity of the trust. He is in no way prohibited from exercising the utmost shrewdness. 143. The second part is that he should stipulate in plain and certain language, in all written contracts and obligations, that the trust only is liable for its obligations and that neither the trustee nor interest holders are to be held to any personal liability in the contract. 144. He may also wish to cite the provision of the trust which so limits his and or the interest holder's liability. But this is often unnecessary, and the trustee should always designate his title either under or immediately next to his name and signature. 145. The trustee should obtain a mailing address for the trust, and though he is the principal and holder of the trust property, it is generally prudent to refrain from mixing the trust's affairs with his own. He should also obtain all separate business necessities, telephone service, utilities, etc., for the trust. Logic follows that he should do these things regardless of whether he is operating trust business or not. He should, for all intents and purposes, maintain a strict separation of the trust's identity from his own, limiting liability and risk. In all contracts, as we have already noted, though it is best to always apply it, the trustee's mere designation of title is not sufficient to limit his liability or remove the risks to his own individual assets. Instead, he must employ the proper language either within the terms of the contract or above or beneath his signature, or in any proper place where it will appear unambiguously, indicating something to the effect of, the property and funds of the trust organization only are liable for contract obligations, individual trustees or interest holders are not personally liable. John W. Doe, acting as trustee under the Declaration of Trust dated October 1, 2005, establishing the trust organization therein called ABC Trust and not individually. John Doe as trustee and not personally, Y as trustee but not personally, or without recourse to trustee. Any form of words that will convey in certain, unmistakable language to the other party that he is dealing with an express trust is sufficient notice under the rule. Whether it is necessary to also cite the provision of the trust instrument which limits his liability is a decision left to the discretion of the trustee. To quote Mr. Justice Woods in the case of Taylor v. Mayo: 146, if a trustee contracting for the benefit of a trust wants to protect himself from individual liability on the contract, he must stipulate that he is not to be personally responsible, but that the other party is to look solely to the trust estate. And in the case of Shoe and Leather National Bank v. Dix 147, the court held, with regard to the promissory note made by the trustees under such limited liability, that it was not within the power of the court to change the trust liability on the note into a personal one of the trustees. That liability on a contract must be determined by the terms of the contract itself, and that a contract entered into under such limited liability, be it a note, agreement, etc., cannot be converted into one under personal liability by law. To do so would be to alter the terms of the contract itself. Furthermore, Any such stipulation is ultimately subject to the acceptance of the other party in order to gain validity in the contract. Banking. The trustee may open any business checking account, financial account, trust account, etc., which he is authorized by declaration to open, but he must keep in mind that by doing so, the trust will be participating directly in that unincorporated interstate banking association with all its limited liability consequences described above. There is only one type of account that avoids those consequences: the non-interest-bearing checking account. When utilized in conjunction with the following banking practices, the trust and the trustee will remain out of the tentacles of public policy. Unless the trustee intends to play within the system, the trustee should never contract for any credit cards, and if the trust has already obtained them, rescind and cancel the contracts. Open a non-interest-bearing checking account in order to avoid the privileges and immunities associated with interest. 148. Maintain a minimum required balance at all times if possible and unless specific transactions demand otherwise. When transacting business, use that bank account solely for depositing the checks and keeping track of the trust funds. Never send or allow trust checks to be sent across state lines. Instead of writing checks, use postal money orders or the bank's corporate certified checks or corporate money orders when sending interstate payments, and use a bonded or non-bonded agent to establish the account on behalf of the trustee. When opening the bank account, non-interest bearing as well as any other, the following must be provided: 1. The original, notarized letter of authorization, or letter of introduction or a limited power of attorney, if being opened by an authorized representative. 149. 2. A copy of the certificate of trust. 3. A copy of the trustee appointment. 4. A copy of the settler's acknowledgement of trust or letter of introduction, introducing the trustee. There are usually 2 introduction or acknowledgement documents per trustee, one regarding his fiduciary powers specifically addressed to banking institutions and one regarding his general power to establish all other accounts. 5. A copy of the first and signature pages of the Declaration of Trust. Note: the bank will almost always require evidence of a trust agreement, but the other documents may be sufficient depending on who you are dealing with. If you can open the account without providing these documents, or with providing only a few of the documents, great. Again, this is a non-interest-bearing checking account, so scrutiny is not a priority. Accounts such as this have been downplayed by banks via advertised interest rates, so most people would rather open accounts that appear to have the prospect of interest earnings. And 6. Only if necessary to obtain a 9. A copy of the filed IRS Form SS4. Take into account the state of ignorance of the law which prevails in America today. Give only the information needed to open the account, but do not arouse suspicion or fear from lack of understanding on the part of bank employees. If you are able to befriend someone in the institution who can establish the account more flexibly, then do it. You must be shrewd in your methods for establishing the account, since, regardless of which bank you choose, you will be dealing with trained employees who, usually, are just a few screws and bolts away from being robots. You should consult the business tactics of successful negotiators who will all attest that the individual who needs the service is at the mercy of the provider, but the individual whose confidence and attitude subtly convey that his business is in high demand is given services, gifts, perks, not to mention any kind of account, just to get his business. It is not my intention to state the obvious, for in all business dealings, which a bank account is, one must be persuasive to get the desired results. And don't be hesitant to shop around, negotiate, bend perception, create competition. In the event it becomes unavoidably necessary to the opening of a non-interest-bearing account, or if the trustee does see fit to obtain an interest-bearing or other financial account, then he, or an agent, must apply to the IRS for an employer identification number, EIN, for banking purposes. This may be done in one of the following ways: instantly, via telephone from 7 a.m. to 10 p.m., local time only, by calling the international applicants line at 215-516-6999, instantly, online by going to http://www.irs.gov/businesses/small/article/0, it equals 98350,00.html, clicking Apply Online, and filling out the online Form SS4 application for employer identification number, and proceeding through the prompts. Be sure to print all the pages for the trust's records, or, by performing the same steps above, but after clicking Apply Online, click Download the Form SS4 PDF file, fill it out, print it, then either send it via mail or carrier to the proper regional office or else the one designated for entities with no legal residence, principal place of business, or principal office or agency in any state, at N. Operation Philadelphia, Pennsylvania 19255, or fax it to faxtin at 2155161040. The form should be filled out according to the specifications of the trust. I have provided an example of how it has been filled out without a problem. In the event that there is a problem and the filing office needs additional information or clarification, they will indicate what is needed, either by fax, phone, or by mail, depending on the contact information given to them. With both telephone and online applications, the trust will immediately be given a temporary IN until the hard copy application, which will be sent to the trust address for completion and endorsement, has been returned to that office within 15 days of the original online application. The IN is valid 24 hours from the moment the voice or electronic application is submitted, but if the hard copy application is not returned within 15 days, the temporary IN will expire and cannot be used. In fact, it is not permanently registered into the Federal Tax ID database until the hard copy has been processed. With faxed applications, the trust will be given a temporary IN by fax within 7 days, which will become permanent once the hard copy application is sent in via mail or carrier. And, with mailed-in applications, the application is processed upon receipt, and an IN is issued via the mail within 2 weeks. The other IN application offices based on region can be found at the IRS internet address given above by clicking Where to File in the side menu located in the left margin of the web page. Transferring assets. There are 3 principal ways to transfer assets into the trust. It may be done via a buy, in precious metals, purchase, in negotiable instruments, or exchange, based on barter. How it is done in any given situation makes all the difference, and there are certain guidelines to follow to ensure the transfer cannot be nullified and voided. As a general rule, the trustee, as owner of legal title to the trust property, cannot buy or purchase the trust property for himself, nor convert it to his own use contrary to the trust instrument. This is generally regardless of whether the property was bought or purchased at a public, private or judicial sale, instituted by him, 150, for he has the unfair advantage, and any such sale, absent certain conditions, is deemed voidable ab initio, to be set aside at the option of the beneficiaries. The only way the property may be obtained is where it can be shown that the interest holder assented intelligently, willfully, and without undue influence arising from the trust relationship. 151 In order to sustain a sale of trust property by the trustee to himself individually, on the ground that the interest holder assented thereto, the evidence must show the good faith of the transaction, the adequacy of the consideration, a full knowledge of the facts, and an independent consent on the part of the interest holder. 152 He may, of course, buy, purchase or exchange trust property in the discharge of his duty to protect the trust. 153 These same principles apply to the selling of the trustee's individual property to the trust, as well as to any barter exchange between trustee and trust. In the case of barter exchange there is an additional option which the trust provides, though it is usually not advisable to exercise it. Simply put, if the contract of transfer is evidently fair and reasonable, untainted by fraud and undue influence. Conveyance of property will be upheld. 154 The contract of transfer need not be a complex document, so long as key principles of equity, the guidelines, 155 are strictly followed. This requires that all necessary warranties be made in the documents themselves in order to legitimize the deal. I have provided a sample bill of sale and asset sale agreement in the sample forms section. The general guidelines are that the seller intends that the buyer shall buy, and the buyer intends that the seller shall sell, or both parties intend to effect a purchase, or that each knowingly intend to exchange one item for the other. The party, especially if trustee, discloses to the trust before the contract is made every fact he has learned in his fiduciary relation which is material to the sale, purchase or exchange. The party, especially if trustee, exercises the utmost good faith in the transaction. No advantage is taken by misrepresentation, concealment of or omission to disclose important information gained as trustee, or agent, and the entire transaction is fair and open on its face. Aside from the general guidelines, there are some specific recommendations for transacting in, as well as purchasing, precious metals for common law purposes. Understand your objective in terms of trusteeship. Contrary to conventional teaching, precious metals are true money, not investments. So, although there may be price appreciation, your primary objective should be wealth preservation, that is, preservation of the trust corpus, not necessarily profiteering, even though a significant profit may likely result to the benefit of the interest holders. Know the size and grade of the coins. The size and grade are critical factors. Size determines how much precious metal you're getting. Grade determines the relative value within the size of the coin. Acquire only low-grade old American gold, graded O or lower. The best form of gold holding is low-grade old American coin in lightly circulated condition, 1850 to 1933. This gold is historically exempt from U.S. gold confiscation laws. Avoid extremely high coin premiums such as CU, BU, MS61 through MS64 and above. Low-end coin not only protects the corpus value, as well as its purchasing power, credit, but is highly liquid, marketable. Always purchase common date coins, not date-specific ones with various mint marks. Pay attention to delivery time. In a normal financial environment, 2 weeks should be the maximum time needed to complete the transaction and delivery of the metal. In an economic crisis, however, demand often exceeds supply, which will alter delivery times significantly and unpredictably. Don't acquire air gold coins, graded MS64 or higher. These coins are not suitable for corpus preservation or common law purposes in general. They are investment grade which focus on quality plus rareness of date and mint mark, and are less liquid as a result. Moreover, due to the small market they appeal to, that is, collectors, it is often difficult to establish fair market values, which tends to give leverage to dishonorable coin merchants. Let the buyer beware. Test the merchant and be sure he does not grade his own coins in-house. Ask his recommendation. If he offers bullion without warning of U.S. confiscation laws, old foreign gold, Hymer's coin, a gold IRA or sells in the name of a religion, beware. Also, you should never place a large order without reliable third-party recommendation in general. At common law, diligence is the responsibility of the party who stands to lose by the lack thereof. Don't convert all trust cash into metals. It is generally recommended that you limit the trust's precious metals holdings to between 10 to 50% of the total net worth of its corpus. If, however, you deem appropriate, it may prove highly advantageous in the near future to convert up to 80% of its total fund holdings. As trustee, it is prudent to keep enough currency for regular expenses, so as not to force yourself to have to liquidate the corpus in order to raise cash for trust expenses. The objective is to only keep as much cash as the trust can suffer to lose in an economic crisis. Acquire gold for corpus preservation and silver for barter. It is recommended that 90% of the trust's metals be in gold because that is its core of wealth and store of value. Gold will be too valuable per ounce for small trade, and therefore should be reserved for the big-ticket transactions only. The remaining 10% of holdings should be in silver for general barter and trade purposes. The silver should be American pre-1964 dated coin, and always take direct possession of the metal. Unless dealing trust to trust within the arrangement you command, never take a paper receipt and allow the seller to hold the metals for safekeeping. Possession is 9/10 of the law, and anything less defeats the purpose behind acquiring the metals in the first place. When transacting trust to trust, or trustee to trust, within the arrangement however, only then is it effective to utilize negotiable instruments such as notes, bonds and drafts issued and drawn against the value of the corpus. This practice keeps in rem jurisdiction, that is, control, over the metals with the trustee and allows for greater flexibility in using the trust's credit and worth. What's more, there is an additional method by which assets may be transferred. This is by way of assignment, either of trustee compensation, venture proceeds or profits, or even the trustee's separate employment wages, salary to the trust as value consideration in the contract of transfer. Whatever the object assigned, that the value consideration shall be in the form of an assignment should be set forth as an express term or provision in the documents evidencing the transfer. 156 A trustee may issue a negotiable instrument, such as a promissory note or bond, to the trust, dividing his personal labor into shares of interest in his trustee compensation, wages, salary, etc., and assigning it to the trust in order to complete the contract. To do this, in addition to the note or bond, he must execute a formal assignment, and then give his employer, payer, etc. notice and instructions to send the payment instrument, for example, employment check, money order, bills, etc., to the trust, which is entitled to endorse the instrument with an authorized signature in the name of the individual trustee per the assignment. It may otherwise be agreed that the trustee shall accept the payment personally, then deliver and sign over the instrument to the trust via a special endorsement of the same. The assignment is akin to a private, quasi-garnishment, in which the employer, payer, etc., is noticed and instructed to send the payments directly to the trust, or deposit the funds directly in the trust's account per the assignment. However, a garnishment proceeding is generally given precedence over voluntary assignments. Sample assignment and notice of assignment forms are provided in the sample forms section. Issuing certificates and bonds. As discussed in the earlier section, the trustees may issue certificates of beneficial or capital interest, or other obligations to any person they choose. 157 There are a total of 100 units of beneficial interest, and a separate 100 units of capital interest in the trust. The trustees determine the number of units, percentage of total interest, to be held by any one interest holder, and may issue the full 100 units, 100%, of either interest to a single individual. To issue a certificate of either interest, the trustees must act jointly as the Board of Trustees, unless there is only one trustee for the trust. They should execute under seal, 158, then deliver to the interest holders the actual certificates evidencing the interest held. The board should also record minutes of the meetings in which it was resolved to issue the interest, and then record the act along with the interest holder's identification information in the appropriate schedule. With certificates of capital interest the method is much different, though the procedure is the same as that for the trust certificates. Capital certificates work based upon barter exchange with investors called exchangers, who may be anyone the Board of Trustees wishes to barter with. The Board of Trustees determines the number of units to issue in exchange for the property proposed for investment into the trust. This is a pure barter between the parties, and whatever number of units is agreed stands as the full value in exchange for the proposed property. 159 The exchanger should present a written proposal, an example of which is provided in the sample forms section, to the Board of Trustees. Any negotiations which take place should be recorded in the minutes in which it is resolved to either issue the interest or refuse the proposal. If the Board of Trustees has resolved to issue the interest and make the exchange, the certificates must be executed and delivered to the interest holders, and the properties in exchange must be delivered by the interest holders to the Board of Trustees. The final act should be recorded along with the interest holders' information, and the property inventoried, in their respective schedules. With bonds, because a bond is merely an obligation or promise to pay money or to do some act upon the occurrence of certain circumstances, the trust need only issue the bond according to the particular transaction. For example, to back the performance of a particular contract, to raise capital from outside investors in the form of IOUs, etc. The distinguishing feature of a bond is that the document shows an obligation to pay some fixed amount of money or services, at a definite time, with stated interest. I have provided some samples for various uses in the sample forms section. Now, there is no rule against a trustee, or agent, of the trust, exchanging his individual property for capital interest in the trust. And there is no rule against the trustee, or agent, holding beneficial interest either, though the holding of beneficial interest is generally regarded with greater suspicion than capital interest. The actual rule is that either transaction will be sustained as non-voidable if it clearly appears free of fraud, concealment, or undue advantage. 160 This means, any omission by the trustee, or agent, to disclose any material fact of the deal which is learned by the trustee by virtue of his office, and any misrepresentation, concealment, or other disregard of condition renders the issuance, exchange, and contract voidable at the option of the beneficial interest holders. And one can wager that any accusation of invalidity of the trust by an outside party will be made on those grounds as well. This suspicion, however unreasonable without regard to the particular merits of the situation, stems from the many express trusts successfully dismantled based upon the unscrupulous and often foolish failing of the control test. In fact, the express trust graveyard is mostly populated with the dead corpuses of trusts who died from this very mistake. When a trustee holds all or a majority of interest, beneficial or capital, in the trust, he is, in effect, an interest holder exercising control over the affairs and rees of the trust. He derives the sole benefit of his actions, and determines the actions which would cause him to derive that sole benefit. He is owner of the legal title to the trust property as trustee, as well as owner of the equitable title to the property as interest holder. At best, the trust is his alter ego, hence he may be proceeded against as though the trust does not even exist. This is why it is recommended that any transfers between trustee, or agent, and the trust, or interest holder, be by sale as prescribed according to the guidelines, through a third party, or by outright exchange, with all documents in support of the transaction ready to repel the outside party who might attempt to come in under the guise of the express trust's grim reaper. Keeping minutes. As mentioned earlier, it is the duty of the trustees to keep minutes for all resolutions, decisions, and acts done in the administration of the trust. This is a form of accounting, and may suffice as the accounting. However, it is recommended that some separate, more detailed accounting always be kept. It is generally best to keep minutes of every Board of Trustees meeting, based upon the notes or report taken during the meeting, or, if there is only one trustee for the trust, on a decision-to-decision basis. How often and by what protocol minutes are kept is, of course, a matter of the trustee's discretion. The rule of thumb is that at least one Board of Trustees meeting regarding general business or the status of the trust should be held, and the minutes kept, annually. They should probably be held, and kept, at least quarterly, in conjunction with all other accounting. The more often the accounting, the more up-to-date, accurate, and reliable the records in administering trust business. Everything the trustee does should be clearly reflected in the minutes, which can be kept using any word processing software, or even a typewriter. The minutes are stored in succession in the minutes book section of the trust binder. I have provided samples of minutes for various acts and resolutions by the Board of Trustees. The format and core language is always the same or similar, prevailing in legal affairs. Here is where we shall get into legal action, the rare instance of public legal affairs, such as determining tax liability, defending a court action instituted against the trust, or trustee, and prosecuting a legal action on behalf of the trust, or trustee, as well as the possible necessity of commencing a private action pursuant to the commercial process. The reader must keep in mind that the chances of an action being taken against the trust or trustee who has properly limited his liability are slim to none. And if an action is taken against them anyway, generally, such cases don't make it past the crucial phase of determining jurisdiction. When one examines the definition of jurisdiction, the fog begins to clear. 161 Jurisdiction, N. 1. A government's general power to exercise authority over all persons and things within its territory. 2. A court's power to decide a case or issue a decree. 3. A geographic area within which political or judicial authority may be exercised. 4. A political or judicial subdivision within such an area. Bold emphasis added. There are two territorial jurisdictions created by the Constitution. The first is the territory, 162, that is, that designated portion of the Earth's surface which is deemed the imperially extensive real estate holdings of the nation over which all power must be exercised within the strict letter of the Constitution. The second is the other property, 163, that is, a territory unincorporated, not included, into the Union of States, over which all power may be exercised strictly according to the mere spirit of the Bill of Rights as interpreted by Congress. The latter is subject to Congress outside the strict letter of guarantees of the Constitution and Bill of Rights. In the former, the federal government can have no direct control over the people but by way of contract, because it is entering onto every scene equally subject to the same laws as all persons, as opposed to the latter wherein the federal government can have full and direct control over people who are beneficiaries of this jurisdiction. As noted earlier, they may act as they see fit, that is, as trustees, for the benefit of public policy regulations, known as codes and statutes, of this jurisdiction. 164. Understanding that most courts currently in business in America are in fact, by the 1938 change in the operation of law, courts of limited jurisdiction, 165 limited to cases involving subject matter of the 14th Amendment public trust, it becomes clear that whether they are distinguished as federal or state courts, such is a distinction without a fundamental difference, all are inherently federal. In order to get at how such courts may obtain jurisdiction over an express trust or its trustees in a legal action, the nature of jurisdiction should be briefly, but sufficiently examined. First, a court must have three essentials: jurisdiction to determine jurisdiction, jurisdiction over the subject matter of the case, that is, it must have the power, competence to decide the kind of controversy involved, and jurisdiction over the parties to the case, that is, in person or personal jurisdiction to compel the parties' performance. If either one is lacking in any way, the court is without power to decide the case. 166 And any order, decree or judgment, other than a dismissal, by such a court is void ab initio. 167 Having only the semblance or appearance of validity. 168 And may be attacked directly or collaterally and vacated at any time. 169 It is settled law that a tribunal has jurisdiction to determine its own jurisdiction. 170 Which brings us to the remaining two elements. Subject matter jurisdiction is like the hub around which the wheel turns. Without the hub, the wheel cannot turn credibly. It is comprised of two parts: the statutory or common law authority of the court to hear the case and the appearance and testimony of a competent fact witness, that is, sufficiency of pleadings. It can never be waived, and it cannot be obtained by lapse of time, consent of the parties, or any event other than the sufficiency of pleadings of the party bringing the suit, that is, the plaintiff. However, although it may have been established by the pleadings, it can still be lost due to, inter alia, fraud upon the court. 171. The judge's failure to follow proper procedure. 172. The unlawful activity or undisclosed conflict of interest of the judge, for example, involvement in a scheme of bribery. 173. The court exceeding its statutory authority. 174. Violation of due process. 175. Improper representation of a party before the court, improper issuance of a summons, or defective service of process. 176. Proper notice not being given to all parties by the movant. 177. The court basing its order or judgment upon a void order or judgment. 178. And violation of public policy. 179. And when subject matter jurisdiction is lacking or lost, the court must discharge its ministerial duty to dismiss on that ground on its own motion, whether it has personal jurisdiction or not. 180. Given the preceding sections on the Unincorporated Banking Association under Form or H.J. Res. 192, and all of the above regarding the other property nature of the states today, it is easy to see why these courts are ipso facto courts of limited jurisdiction, having no jurisdiction over subject matter in the territory. But assuming for the sake of explanation that subject matter jurisdiction did exist, then personal, or personal in rem 181 jurisdiction over the trust and its trustees can only be obtained in four ways, either by the trusts or trustees. Presence 182, that is, his being served with a copy of the summons and complaint while physically present in the forum jurisdiction. Domicile 183, that is, residence alone is a basis for exercising jurisdiction. In the case of corporations, domicile is the state in which they are incorporated, and in the case of express trusts, the place of their situes. Permission or consent 184, that is, a trustee either personally or on behalf of the trust, having not been properly served, can nevertheless give the forum court permission to exercise jurisdiction. Depending on the act of the trustee, permission can be given well in advance of any lawsuit filed, and the consent can also be implied. And minimum contacts 185, that is, having sufficient dealings or affiliations with the forum jurisdiction which make it reasonable to require the trustee to defend a lawsuit brought in the forum state. If the state has no contacts, ties or relations with the trust or trustees, personal jurisdiction cannot be obtained in this manner. 186. The four principles of minimum contacts are, that 1. The trust's or trustee's activity must be continuous and systematic in the forum jurisdiction, and the cause of action must be related to that activity. 2. Sporadic or casual activity of the trust or trustees in the forum jurisdiction does not justify the exercise of jurisdiction in a cause of action unrelated to that activity. 3. If the trust's or trustees' contacts are sufficiently substantial and of such a nature as to make the exercise of jurisdiction reasonable, then General 187 jurisdiction may be exercised by the forum over the trust or trustees, and 4. If the trust's or trustees' activity is sporadic or consists only of a single act, then specific 188 jurisdiction may be exercised by the forum only when the cause of action arises out of that activity or act. Unlike subject matter jurisdiction, once personal jurisdiction is obtained, it can rarely be lost, and if the trust, or trustee, permits or makes an unrestricted appearance, it cannot be later denied. Contrary to the general appearance which constitutes consent, the trust or trustees may avoid personal jurisdiction by making a special or restricted appearance for the purpose of attacking the forum court's personal jurisdiction, 189, and may even attack, so to speak, subject matter jurisdiction. Generally, a challenge to subject matter jurisdiction constitutes consent, a waiver of personal jurisdiction for the purpose of arguing, but this doctrine does not apply to cases involving express trusts over which subject matter jurisdiction clearly does not exist. 190. Upon further analysis of the preceding diagram, we see the following. Presence: the trust is created and functioning in the territory, doing business under the general common law, not the private law of the Unincorporated Banking Association. Presence can therefore only be construed to exist where the trust has become a member of that association via residence in a revenue district, indicated by zip code, or by engaging in a particular transaction. Even then, the trust or trustees must be present by membership or transaction in that particular political subdivision, state, and given notice reasonably certain 191 to reach them. That is, service of process via either personal service, substituted service, or constructive service, as service by mere publication in a newspaper of general circulation has been held insufficient in such cases. 192. And, as a side note, mere physical presence in a courtroom during some phase or proceeding does not constitute an appearance. 193. Domicile: the situes of the trustees in the United States of America. designating the territory, the union of states as the land of which the common law is supreme law. Unless the trustees, in behalf of the trust, adopts a principal place in the other property, establishes a residence in a place subject to the federal jurisdiction with the intention to make it its domicile. 194 Personal jurisdiction is lacking in this respect. It must purposely establish an address directly in a revenue district. For example, via post office box, or street address, to be liable in this way. But if the trustees contracts with a private mail service provider or carrier, signing without prejudice, then personal jurisdiction does not attach. This effects an exclusion of any third-party intervener, overseer, and reserves the obligation to the course of the common law of contracts, that is, bilateral contracts, not trilateral ones. Permission. It may seem tricky, but it is rather simple. Any answer to any presentment from a forum jurisdiction constitutes giving them permission to exercise authority, unless it is specifically a special or restricted appearance for the sole purpose of challenging their authority. Personal jurisdiction. If the trustees do not answer in general, or subordinate themselves, then consent has not been given. And if the trustees, presumably under properly limited liability, enter into a contract under a forum selection clause, then the forum selected will have personal jurisdiction. However, there are limitations to what constitute an enforceable forum clause, for if the clause is expressed in fine print, placed in the contract so as to avoid litigation, 195 unreasonable or ambiguous, 196 not fundamentally fair, 197 or if the clause could not have been disputed without impunity as a part of a freely negotiated contract, then it is invalid. Minimum contacts. The trust must purposely avail itself of benefits, and services, of the state. 198, for example, license, registering ownership there, contracting with the government there, availing itself of benefits or services of the legal system there, court actions, utilizing police or fire services, etc., systematically and continuously, or sporadically but substantially enough so as to warrant the trust or trustees being compelled to come into the forum. 199 I will not get into diversity of citizenship here, though it is wholly important to subject matter jurisdiction in the federal courts, for it is highly improbable that it would even be necessary to bring it up in such an action, given all of the above with which the express trust is naturally armed. 200. As a final note, when the express trust is taking an action against an outside party, the most effective method is via the commercial process, that is, a private, out-of-court, legal action instituted under the fundamental rules of commerce, trade, business. Lawsuits should be regarded as a last resort to secure judicial enforcement of a private judgment, for public suits confer full personal jurisdiction upon the court. Taking a claim to a legislative court avails the trust of several benefits and services of that forum, and thereby establishes a substantial minimum contact. Even still, any action for judicial enforcement of a private judgment can be done out of court pursuant to the commercial process. In private actions, the maxims of commerce, the foundation of all commercial law and Western legal systems, govern. A workman is worthy of his hire. Exodus 20:15, Lev.19:13, Matt.10:10, Luke 10:7, and 2 Tim 2-6. Legal maxim: it is against equity for freemen not to have the free disposal of their own property. All are equal under the law. Law of God, moral and natural law. Exodus 21:23-25, Lev. 24:17-21, 117, 1921, Matt. 22:36-40, Luke 10:17, and Col. 325. Legal maxim: no one is above the law. Commerce, by the law of nations, ought to be common, and not to be converted into a monopoly and the private gain of a few. In commerce truth is sovereign. Exodus 20:16, ps. 117-2, John 8:32, and 2 Cor. 13-8. Legal maxim: to lie is to go against the mind. Oriental proverb: of all that is good, sublimity is supreme. Truth is expressed by means of an affidavit. Lev. 5-45, Lev. 6-35, Lev. 19:1113, Num. 30-2, Matt. 533, and James 5:12. An unrebutted affidavit stands as the truth in commerce. 1 Pet. 125, Heb. 6:1315. Legal maxim: he who does not deny, admits. An unrebutted affidavit becomes the judgment in commerce. Heb. 6:1617. Any proceeding in a court, tribunal, or arbitration forum consists of a contest, or duel of affidavits wherein the points remaining unrebutted in the end stand as the truth and the matters to which the judgment of the law is applied. A matter must be expressed to be resolved. Heb. 4:16, Phil. 4-6, and if. 6:1921. Legal maxim: he who fails to assert his rights has none. He who leaves the field of battle first loses by default. Book of Job, and Matt. 10:22. Legal maxim: he who does not repel a wrong when he can, occasions it. Sacrifice is the measure of credibility. One who is not damaged, put at risk, unwilling to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions has no basis to assert claims or charges and forfeits all credibility and right to claim authority. Acts 7, Life and Death of Stephen. Legal maxim: he who bears the burden ought also to derive the benefit. A lien or claim can be satisfied only through rebuttal by counter-affidavit point for point, resolution by jury, or payment. Gen. 2-3. Matt. 4, and Revelations. Legal maxim: if the plaintiff does not prove his case, the defendant is absolved. Maintaining proper IRS relations. Last but not least, due attention must be paid to the Internal Revenue Service, for they are the lawful, legal entity, duly authorized to collect association dues, income taxes, from 14th Amendment citizens and other persons volunteering and availing themselves of the privileges and immunities regarding non-payment of debts in the system implemented under Form or H.J. Rees. 192, 12 U.S.C. Section 95A, and 15 U.S.C., ch. 41, Section 1602c, d.e. They, participants, are considered as a debtor, creditor in a social security association, unchartered, unincorporated commune, whereby each person ensures everybody else in the association by agreeing never to demand payment for debts. It is, under this volunteer arrangement, that these persons become primarily a U.S. citizen, secondarily a state citizen, subject to Clause 1 of the 14th Amendment, while the literal 10th Amendment rights are forfeited. 201. Persons under this system have only relative rights to life, liberty, and property. Their natural rights are converted into privileges and immunities and civil rights. As debtors, they have no absolute literal property ownership, for it has thus been converted to mere usership. 202 Plainly put, IRS taxes serve several functions, but principally as dues for the privileges and immunities associated with participating in the Federated Unincorporated Interstate Banking Association for the non-payment of debts. 203 What's more, the collection of income taxes is crucial to maintaining order within the association, more so than for any proposed funding of the association. 204. But that has no bearing on a properly created and administered express trust. It is well settled that a trust, created by parties not availing themselves of such privileges and immunities, is not illegal even if formed for the purposes of limiting or avoiding taxes altogether. 205 Nor is the express trust subject to federal excise taxes imposed on corporations. 206 Nor is an express trust taxable merely because it possesses all the accessory powers possessed by corporations. 207 Nor can the dignity of its trust instrument be set aside simply because a tax benefit results, whether by design or by accident. 208 Frankly, unless it incurs a tax liability in the United States via a valid forum clause in a contract, membership in the unincorporated banking association, becoming an employer, employee, or worker, or corporate entity, deriving income from corporate stocks or physical franchises, accepting other privileges and immunities under the 14th Amendment, or availing itself of any other benefits of the public trust invoking the doctrine of reciprocity, it has nothing to do with the IRS. However, as it might stand as a beacon of organizational liberty, the IRS has a reasonable interest in making sure the express trust example does not upset collections and, most important of all, compliance. The IRS, thus, takes every precaution to shoot down trusts of any kind which even hint at having origins lying outside of its jurisdiction, that is, the other property. It is interesting to note that the IRS-taxpayer relationship, by operation of law, is that of beneficiary, cestui qui trust, to trustee. It is a classic resulting trust. The taxpayer is presumed to be a trustee, hence he is legally obligated to report and make distributions to the party having a legal right to certain amounts pursuant to the trust bylaws, that is the U.S. tax code. It becomes understandable, then, that the IRS would construe every instance, no matter how rare, of a non-statutory trust condemned in court as being attributable to some purported inherent unlawful nature of non-statutory trusts in general. Hence the classification of abusive trust, though any trust, statutory or non, express or implied, resulting or constructive, which abuses the fundamental principles upon which equity rests is, technically, abusive. Yet, they never speak of them. The reader should therefore be keen to know how to discern good information from dis and misinformation. In the event the IRS takes an action against a purported common law trust or pure trust, aka poor trust, it is generally a lawful action, actually in response to some unlawful activity on the part of the parties or defect in their contractual relations. Your author has never seen an action taken against a properly drawn express trust, that is, one drafted from the perfected language and form of that best legal talent 209 to which the power and superiority of the express trust is attributed. Even in those cases, a thorough analysis of jurisdiction, such as the one treated in the previous section, sheds light on the blatant limitations of the IRS's, and courts in general, jurisdiction. The fact that they manage to establish subject matter jurisdiction and personal in rem jurisdiction attests to the ignorance of the defendants, and indeed, personal jurisdiction usually would never have been obtained without the defendant's unwitting permission. 210 It is no secret that all actions of the IRS are commenced as proceedings in admiralty. 211 Conclusion. The only way to thrive in 21st century America is to own nothing and control everything, privately. And though any trustee is the legal owner of the property in trust, the trustees of express trusts do not experience the incidents of personal ownership due to properly limited liability via trust instrument and the cardinal virtues of the trustees. It is this limited liability that makes the express trust no less than the corporation. But it is the latitude of choice of whether to function in the common law venue with absolute rights in commerce under the general law merchant or in the Roman civil law venue with only relative rights in commerce under private international law that makes the express trust, inter alia, far superior and profitable. Under the aegis of the express trust, the trustee is clothed in a veil impenetrable but from within. This suit of armor is the trust instrument, which molds to the trustee in all his good faith dealings on behalf of the trust, fully compensating him for his services, privileging his use of trust property, and enabling his exercise of creativity in business endeavors, all without the excessive weight of inquisitorial legislation. The greater latitude afforded under express trusts manifests itself in a number of ways, one of which is in the prosecution of claims and commercial liens wherein the trust acquires for value the account of a debtor, and the trustee utilizes the trust's qualities in order to effectively collect the debt owed. The trust brings with it a form of professionalism and authority which enables the debt to be collected honorably. And when one is trustee, he is in a fiduciary position generally looked upon with respect for the integrity inherent in the position. This has always been the case, except where the power has been abused. But even so, history is clear that there are far more abuses of power via corporations than express trusts. 212 Given the statistics, and the fact that all governments in 21st century America are corporations themselves, it becomes clear that the extensive recognition given to corporations by the state is simply because of the special interest relationship between the two. In a way, It is the same relationship between the John and the prostitute, 213. For it is always in the best interest of the prostitute to take measures to keep the John in business. This is done in order to indirectly protect her own job security. This is also the underlying cause for much of the negative sentiment towards express trusts operating in the statutory world. It is this relationship that has bred the irrational view that some trusts have been created independent of statute. Some non-statutory trusts are said to have done harm. Therefore public policy demands that hereafter all trusts shall be regulated. The irrationality of this becomes more apparent when the syllogism is paraphrased thus: some lawyers have been presidents of the United States, some presidents are said to have done harm. Therefore public policy demands that hereafter all lawyers shall be prohibited. The bottom line is that the express trust relation is the most effective means to owning nothing while controlling it all, and, when utilized properly, it affords its participants with all the ingredients of legal health and commercial wellness. It is also true that no matter how many arguments are made against the express trust, the learned reader will always see through the propaganda and spin, knowing the state's nagging concern is the utter lack of in rem jurisdiction over express trusts. Possession is 9/10 of the law. At the end of the day, in rem jurisdiction remains in the private venue, that is, with the trustee pursuant to the private contract between he and the settler. So, from natural deduction, it should become clear that the express trust can really only fail due to some misgiving or impropriety on the part of the trustee. The trustee must therefore trust himself. Carton Weiss, May 1, 2007. Sample forms: form name, form description, asset sale agreement, agreement to buy assets by trust, assets to be bought with silver, gold from trustee in individual capacity. Assignment of bank account. This form assigns a bank account and all deposits in it over to the trust for value received and also serves as notice to the bank to act on the assignment accordingly. Assignment of copyright. This form provides for an outright assignment of a copyrighted work to the trust. Assignment of wages. Under this agreement, a person's right to employment wages is transferred to the trust. Attorney-retainer agreement. This is a retainer agreement with a special jurisdictional understanding, excluding attornment with services provided under reservation of rights and with protection against minimum contacts. Authorized rep. Contract between trust and authorized rep setting forth terms and conditions of the position. Authorized rep. Introduction. Letter of introduction introducing authorized rep to third parties with whom authorized rep will be in contact in certain trust affairs. Bill of sale of property of whatever kind. Seller is trustee in individual capacity. Buyer is trust. Transaction completed by authorized representative on behalf of trust. Bond. Basic. This form is a bond that secures the indebtedness of the principal in lawful money of the United States. Bond. Indemnity. This form is a bond that provides for a principal indemnifying the trust or trustee of all risks and liability contingent upon a certain event. Independent contractor agreement provides for a short form independent contracting agreement for virtually any type of services which can be performed by an independent contractor. Use this form to establish a contractual relationship with someone who is performing services for the trust. IRS Form SS4. This form is to be filled and submitted to the Internal Revenue Service for issuance of an employer identification number, IN, for banking purposes. Lease with option to buy. This agreement provides for a lease of trust property with an option for the renter to buy the property for silver, gold. Limited power of attorney. Limited power of attorney authorizing third party to act on behalf of trust. Management agreement provides for a management agreement for either a business, services or other matters between a management trust and client trust. Meeting. Annual minutes for the annual meeting of the Board of Trustees. Standard business discussed. Meeting. Notice. Regular notice of meeting of the Board of Trustees. Meeting. Real estate assets. Minutes of meeting wherein Board resolved to accept real property, real estate into Trust Corpus. Meeting. Revocation of beneficial interest. Minutes of meeting wherein Board resolved to revoke the beneficial interest of a beneficiary in trust. Non-recourse promissory note. This note establishes a legal obligation, but does not make the trust the note liable except for any collateral which was pledged. Notice of assignment and instructions for payment. An assignment of a check or funds usually occurs by endorsement, but notice can be given to employer of assignment instructing that payments are to be sent directly to trust. Notice of private sale of collateral. Notice given to debtor by the trust that collateral will be sold privately on a set date and time, and that debtor will be liable for any unpaid balance. Offer to buy automobile. Like any property deal, a person can submit a formal offer to the owner of a car. Upon signature, this becomes a binding agreement for the sale. Proposal to exchange property. Proposal to exchange property into trust in exchange for capital interest. Asset sale agreement. This asset buy agreement. This agreement is made and entered into as of this 8th day of January, 2007, the effective date, by and between John W. Doe, individually and in his personal capacity, seller, and ABC Trust, an express trust organization. Buyer. Recitals. A. Seller wishes to sell the personal property, in as is condition identified in Exhibit A, assets, attached hereto and incorporated by reference. B. Buyer wishes to buy the assets in as is condition. C. Seller desires to sell to buyer, and buyer desires to buy from seller the assets on the terms, conditions, and warranties as set forth herein, in consideration of $2.99 silver, the foregoing and the mutual promises and warranties contained herein, and good and other valuable consideration, the receipt and sufficiency of which is hereby acknowledged. Buyer and seller agree as follows. 1. Closing and possession. The sale of assets shall be effected as of the closing date by seller's execution and delivery of a bill of sale, the bill of sale, and other instruments of conveyance and transfer reasonably necessary to effectively transfer to buyer all of seller's right, title and interest in the assets. At the closing, seller shall sell, transfer, convey, assign and deliver good title to the assets pursuant to the instruments of conveyance, that is, the bill of sale, free of all liens, encumbrances, claims, and any other restrictions whatsoever. 2. Assets to be purchased. On the closing date, seller shall sell to buyer, and buyer shall buy from seller, the assets listed on Exhibit A attached hereto and made a part hereof in accordance with the provisions of this agreement. 3. Purchase price. The total sale price for the assets is $2.99 silver payable to seller. The purchase price, as follows, in one lump sum payment. 4. Representations, warranties, covenants and disclosures of seller. Seller represents, warrants, convenants, and discloses to buyer, and understands that buyer will rely on such representations, warranties, covenants and disclosure of seller, as follows. A. Seller has all requisite power and authority to own the assets, to enter into this agreement, and to consummate the transactions contemplated by this agreement, and does so willingly and freely. Entering into this agreement and carrying out the actions provided for in this agreement will not cause seller to be in breach or violation of any other agreement or legal obligation. B. Seller, by his position as trustee of ABC Trust, hereafter the trust, has learned of buyer's total available funds, which exceed the value of the assets. Furthermore, seller has made buyer privy to seller's total costs and profit potential in the transaction contemplated by this agreement, and specifically warrants that the purchase price is fair and reasonable. C. Seller, in the transactions contemplated by this agreement, has exercised no unfair advantage gained by his position as trustee of the trust, either by way of misrepresentation, concealment of, or omission to disclose important information obtained by his position. D. Seller is not aware of any liens and encumbrances on the assets as of the date of this agreement, or that any liens or encumbrances are likely to occur against the assets at some future point. E. The fair market value of the assets being sold as is no less than the purchase price. F. Seller has not assigned, transferred or given as collateral to any party other than buyer any right or interest of seller in the assets. G. Seller is not aware of any actual or potential claims against the assets that would delay the closing of the distributions of the trust and or materially reduce seller's interest. Asset Sale Agreement, page 1 of 3. H. Seller is not and shall not be a party to any agreement or transaction that could have the effect of impairing buyer's right to receive distributions from the trust up to the full value of the assets. I. To the best of seller's knowledge and belief, The fair market value of the assets are as represented in Exhibit 2 and any additional documents provided by seller. J. There are no facts or circumstances known to the seller that may adversely affect the value of the assets or prevent or delay the distribution of trust cash or assets to seller. K. If seller's interest in the assets arises out of a will, seller is the individual referred to in the will and seller is not aware of any persons who have, or may contest. L. Seller's entitlement under the will, the validity of the will, or the distribution of assets of that estate as provided for in the will. M. Seller has not entered into this agreement with any intent or purpose to avoid or defraud any creditor of seller. N. Seller does not now or in the immediate future contemplate filing for bankruptcy and has not consulted any lawyer or other professional regarding the possibility of a bankruptcy filing, assignment for the benefit of creditors, or any other insolvency proceeding. In the event that seller should file for relief under Title 11, United States Code, seller acknowledges that buyer shall be entitled to enforce all its rights as a creditor secured by a lien on all of seller's distributions from that estate pursuant to 11 U.S.C. Section 506. Including rights to seek adequate protection of such interest as defined by 11 U.S.C. Section 361, and O. Buyer is entitled to rely on each and every of the representations and warranties set forth in subparagraphs A through N above. 5. Additional protection for buyer. Seller grants buyer a security interest in all of seller's estate, including seller's interest in other estates, as collateral to secure payment of the value of the assets and any damages, expenses, costs and fees to buyer for any default of this agreement by seller. Buyer may at any time file a UCC-1 or other documents perfecting buyer's security interests pursuant to this agreement. Buyer will release the UCC-1 when the value of the assets and, if applicable, damages, expenses, costs and fees have been paid in full to the trust. 6. Closing documents and procedures. At the closing, the parties shall deliver to each other the following: A. Bill of sale. Seller shall sign and deliver to buyer the bill of sale. B. Payment. Buyer shall pay the certain amount of $2.99 silver, face value, and such other documents, instruments, and confirmations as the parties may reasonably request to effectuate and consummate fully the transactions contemplated by this agreement. 7. Brokerage. No agent, broker, person, finder or firm acting on behalf of seller or under its authority is or shall be entitled to any commission or broker's fee or finder's fee from buyer or seller in connection with any of the transactions described in this agreement. Seller and buyer each represent and warrant to the other that they have not dealt with any broker, finder or other person entitled to any broker's or finder's commission, fee or other similar compensation in connection with the transactions contemplated by this agreement. 8. Miscellaneous. A. Complete agreement. This agreement and the exhibits hereto contain the final, complete expression of the understanding among the parties with respect to the transactions completed by them and supersedes any prior or contemporaneous agreement, representation or understanding, oral or written, by any of them. The terms and provisions of all exhibits, as set forth in the table of contents, are incorporated into this agreement. B. Attorney's fees and costs. In any action or dispute, at law or in equity, that may arise under or otherwise relate to this agreement, including, but not limited to any action regarding non-competition, the prevailing party shall be entitled to reimbursement of its attorney's fees, costs and expenses from the non-prevailing party. Asset sale agreement, page 2 of 3C. Assignability, successors and assigns. This agreement is not assignable by any party without the prior written consent of all of the parties, and any attempted assignment without the prior written consent of the other parties shall be invalid and unenforceable against the other parties. D. Governing law and forum. This agreement is governed by the general common law of contracts. Any disputes under this agreement, or any action taken to enforce or determine the rights and obligations of the parties under this agreement must be brought in the appropriate federal or state court located in state wherein obligation was made. The parties hereby submit to the jurisdiction, and waive any objection to the venue, of such courts. Binding effect. This agreement shall be binding on and anew to the benefit of the parties and their respective successors in interest, heirs, successors and assigns. All parties bound by this agreement shall take any and all actions necessary or appropriate to effectuate the agreement's purposes and provisions. The parties hereto have executed this agreement on the day and date first written above. Seller. Buyer, John W. Doe. Individually ABC Trust by, _ Richard Rowe, Attorney in fact we, Concise Trust, as beneficiary of buyer, do hereby consent, freely, willfully, intelligently, independently, and without undue influence of seller or authorized representative, to the transaction contemplated by this agreement on this day of 2007 Jane Public. Trustee Asset Sale Agreement. Page 3 of 3. Assignment of bank account. Be it known, that for consideration the undersigned, John W. Doe, assigner, hereby sells, assigns, transfers and irrevocably sets over to ABC Trust, an express trust organization, $10,000, $10,000 and $100, US, of the sums on deposit in my name, savings account number 123,456,789, in First Colonial Bank located at 1234 Letter Avenue, and further authorizes said bank to pay over to ABC Trust, assignee, said sum out of money on deposit in said bank account in the undersigned's name. This assignment shall constitute notice to First Colonial Bank of this assignment and direct authorization to such bank to act on this assignment. John W. Doe, seller in witness whereof, the undersigned executed this assignment on this day of 20 before me a notary public in and for Acton County, Ohio, notary public. My commission expires, assignment of bank account. Assignment of copyright. For value received, John W. Doe, the undersigned hereby sells, transfers and assigns unto ABC Trust, an express trust organization, including its successors, assigns, and personal representatives, all right, title and interest in and to the following described copyright and rights pertaining to said copyright, and to the works described as follows: title, registration hash, if any, nature of work, the undersigned warrants that it has good title to said copyright, that it is free of all liens, encumbrances or any known claims against said copyright. This assignment shall be binding upon and anew to the benefit of the parties, their successors, assigns, and personal representatives. Dated ABC Trust John W. Doe by Richard Rowe, Attorney in fact Jane Public. Witness. Assignment of copyright. Assignment of wages for good and valuable consideration and to satisfy indebtedness. I, John W. Doe, referred to as assigner, herewith unconditionally assign, transfer and set over to ABC Trust, an express trust organization, referred to as assignee, all of my right, title and interest in 100% of net wages earned per pay period for a total of 52 pay periods, not to exceed the aggregate assignment amount of $100,000, under my contract of employment with Colonial Financial Corporation located at 1234 Letter Avenue. This assignment is absolute, irrevocable, and indivisible. Further, this assignment shall be binding upon me, my heirs, executors, administrators and assigns. Payments to assignee hereunder shall be in the usual and ordinary manner of conducting business in accordance with my employer's company policy. Assigner shall discharge from any and all liability arising out of this assignment. Amounts assigned hereunder are subject to the terms and conditions of the employment contract. Dated, John W. Doe, assigner Richard Rowe, authorized agent for assignee. Acknowledgement state of SS, County of on this day of 2007, before me, a notary public, came John W. Doe and Richard Rowe, in behalf of assignee, personally known to me, or proved to me on the basis of satisfactory evidence, to be the persons whose name is, are subscribed to the within instrument and acknowledged to me that he or she, they executed the same in his/her/their authorized capacity. and that by his/her/their signatures on the instrument the persons, or the entity upon behalf of which the persons acted, executed the instrument. Witness my hand and official seal. Notary public my commission expires. Assignment of wages. ABC Trust, a trust organization in care of 1234 Number Street, Cleveland, Ohio, 54321 12345678890. January 8, 2007. John Esquire and Esquire, LLC. 1234 Number Street, Cleveland, Ohio 54321. Attention, John Esquire. Dear Sir, we contract your offices to represent ABC Trust in the following manner and under the following conditions in regard to its claim against First Colonial Bank. This contract shall be entered into with the understanding that we reserve all our rights against any presently undeterminable or adhesive terms, provisions, and jurisdictional attachments such as any which might arise from the Ohio BAR or any other associations in which you might hold membership, etc. We shall contract you solely as attorney in fact, in a private authorized representative capacity in exclusion of any such membership or office in any court. You shall not act as ABC Trust's legal guardian in fact or in any other capacity which might create the presumption of ABC Trust being a ward of the court. ABC Trust retains its jurisdictional independence and original legal character regardless, and all services shall not include services or acts properly understood or legally classifiable as attornment. Attornment, whence the term attorney is derived, is defined in Black's Law Dictionary, 1st ed., at p. 105, thus, in feudal and Old English law, a turning over or transfer by a lord of the services of his tenant to the grantee of his seigneury. No such act or related acts, however construed, are contemplated by this contract. We agree to pay you a retainer of $3,000, US, to be delivered upon your acceptance of the terms of this agreement. If this arrangement is indeed acceptable, please sign and return a copy of this letter to us. Sincerely, John W. Doe, Trustee for ABC Trust in care of 9876 Number Street, Cleveland, Ohio 98765, accepted on this _day of _2007 by _John Esquire. Attorney Retainer Agreement. Authorized Representative Contract. ABC Trust, an express trust organization, referred to as Trust, and Richard Rowe C. 9876 Number Street, Cleveland, Ohio, 54321, referred to as Authorized Representative, agree as follows. Witnesseth, whereas, Trust has certain duties, responsibilities, and obligations which Trust desires to delegate to another, specifically to Authorized Representative for a 25-year limited period of time, and on the terms and conditions, and for the consideration hereinafter set forth, and whereas, Authorized Representative is qualified to provide such management services and desires to provide such services to Trust on such terms and conditions and for such consideration. Now therefore, in consideration of the foregoing and the covenants and agreements contained herein, the receipt and sufficiency of which are hereby acknowledged, and the parties hereto, intending to be lawfully and legally bound, agree as follows. Statement of Agreement. Article I. Affiliation and Duties. 1.1 Affiliation. Effective date. Trust agrees to engage the services of Authorized Representative, and Authorized Representative agrees to provide services to Trust, commencing as of the date of this agreement subject to the terms and conditions of this agreement. 1.2 Position. Trust shall engage the services of Richard Rowe in the position of Authorized Representative. As such, Authorized Representative shall have the responsibilities, duties, and authority enumerated under the Articles of Indenture of Trust as well as those customarily pertaining to such position consistent with such a trust organization and such other services as may be requested of Authorized Representative by Trust. 1.3 Primary Duties and Services. Trust hereby appoints Authorized Representative to be the day-by-day manager with respect to any and all dealings, business or otherwise, Trust may have, trust does so for the purpose of providing for a day-by-day manager to be solely responsible for any and all activities of trust. 2. Authorized representative agrees to serve in said position and to perform diligently and to the best of authorized representative's abilities said duties and services referred to in section 1.2, and in such a manner as authorized representative deems advisable within the parameters as established and acceptable to trust, as well as such additional duties and services appropriate to such position which the parties mutually agree upon from time to time. 3. Authorized representative shall have the ability and authority to perform such duties in accordance with authorized representative's sole judgment and discretion. 4. Authorized representative shall be solely responsible for obtaining and maintaining all appropriate information concerning the day-by-day, as well as business plans and future activities of trust. Trust does hereby transfer all absolute authority to authorized representative to manage the business and day-to-day operating affairs of trust. 1.4 Other interests. During the period of time as set forth in this agreement, authorized representative shall have full discretion to devote as much time and effort in performing her duties as authorized representative deems necessary in order to carry out and maximize authorized representative's performance hereunder. Authorized representative may engage, directly or indirectly, in other related business that do not conflict with authorized representative contract. Page 1 of 4 Representatives' duties hereunder and or the business of trust. The foregoing limitations shall not prohibit authorized representative from serving in other capacities for other organizations, or on trusts of other organizations, provided that authorized representatives' service in such other capacities for such other organizations and are on such trusts is not adverse to the interests of trust. 1.5 Independent status. Authorized representative shall be maintained as an independent contractor for purposes of taxation and liability. Authorized representative shall be solely responsible for any and all withholding of applicable tax, as well as any and all contractor-related expenses. 1.6 Primary office location. Authorized representative shall perform his or her duties at any location which he or she deems appropriate, but shall represent the address of trust as the primary office location for any and all accounts, transactions, and business of trust, as well as for all expenses incurred by trust. Authorized representative shall represent the address of trust as her official primary office location for all such purposes. 1.7 Bank and other financial accounts. Authorized representative shall have the ability and authority to open bank and other financial accounts in the name of trust, and to obtain any and all services with any institutions authorized representative may deem necessary and beneficial to trust. All monies for accounts of trust shall be maintained by authorized representative. 1.8 Contracting. Authorized representative has the ability to bind trust in any manner, upon prior approval of and notification to trust. 1.9 Business and other materials. Authorized representative shall have sole discretion in the production and or distribution of all such materials representational of trust's business and other interests, including but not limited to any stationery or business cards representing trust. Article 2 Term, duration, and termination. 2.1 Term. Authorized representatives' affiliation by trust shall commence on the effective date as set forth in Article 1, Section 1.1. Authorized representative shall perform his duties for a period of 25 years or until termination by either of the parties as herein provided. Authorized representative contract is automatically terminated upon authorized representative's death, sale of trust business, or all of trust's assets, leaving trust with nothing of value. This contract can only be terminated by a determination of malfeasance by a judge of a court of competent jurisdiction, or by a determination of mental incompetence of authorized representative by a recognized medical authority appointed by such a judge. 2.2 The parties' right to terminate. The provisions of this article are in no way intended to take away or otherwise waive any rights that trust may have under the law. The parties shall have the right to terminate this agreement at any time with 60 days prior written notice for cause, which for the purposes of this agreement shall mean, a. authorized representative's dishonesty or fraud with respect to the reputation and our affairs of trust which materially and adversely affects the business and other relations of trust, provided authorized representative fails to cure such ill repute within a reasonable period of time, or b. a material breach by authorized representative or trust of this agreement or any other agreement by and between authorized representative and trust, provided either party fails to cure such breach, if curable, within 30 days of receipt of written notice thereof. Upon termination of this contract for any reason the current or resigning authorized representative can only be replaced by the first in line successor authorized representative. This shall in no way affect or preclude the consummation of any transaction which was effected prior to such termination. Article 3 Compensation and Fees. Authorized Representative Contract, page 2 of 4.3.1 Contractor Fee. Trust shall pay authorized representative a monthly fee of $500, $500 and no $100, US. This fee is payable upon the acceptance of this contract and is payable each month thereafter. All checks must be made payable to the current authorized representative. The amount of this fee may be increased only upon amendment of this contract ratified by written consent and approval of trust. 3.2 Expense reimbursements. During the term of this agreement, authorized representative shall be solely responsible for any and all contractor-related expenses. All expenses, out of pocket and otherwise, which are incurred as a result of, as well as in the course of, carrying out the duties and responsibilities of authorized representative shall be reimbursed to authorized representative. All reimbursements shall be made to authorized representative separately and aside from the managing fee and in a manner agreed upon by the parties. 3.3 Termination by authorized representative. If authorized representative's affiliation hereunder shall be terminated by authorized representative, then, upon such termination, regardless of the reason thereof, all compensation derived from managing fees and expense reimbursements shall be paid within 30 days of written notice of termination. Article 4 Miscellaneous 4.1 Assignment and Governing Law. This contract shall constitute a binding contract under common law of contracts upon acceptance by the parties. This contract may not be assigned by either party without the other party's written consent nor by operation of law. This agreement shall be binding on the successors and assignees of the parties. 4.2 Reservation of Rights. The parties do hereby enter into this agreement without prejudice to any rights otherwise waived due to any non-disclosure or adhesion. 2. The parties acknowledge that trusts property and funds only are liable under contracts, and that individual trustees, officers and interest holders are not personally liable. 3. Trust in no way relinquishes ownership of any of trust's properties. 4. The failure by either party hereto at any time to give notice of any breach by the other party, or to require compliance with any condition or provision of this agreement shall not be deemed a waiver of said breach or non-compliance, or of any similar or dissimilar provisions or conditions at the same, or at any prior or subsequent time. 4.3 Severability. If a court of competent jurisdiction determines that any provision of this agreement is invalid or unenforceable, then the invalidity or unenforceability of that provision shall not affect the validity or enforceability of any other provision of this agreement, and all other provisions shall remain in force and effect. 4.4 Withholding taxes. Trust shall not withhold from any compensation made to authorized representative, pursuant to this agreement, any applicable taxes as may be required pursuant to any law. Authorized representative is not an employee of trust. 4.5 Headings. Paragraph headings have been inserted for purpose of convenience and shall not be used for interpretive purposes. 4.6 Modification. Any modification of this agreement shall be effective only if in writing and agreed to by the parties in writing. Authorized representative contract. Page 3 of 4 In witness whereof, the parties hereto mutually and individually agree to the above enumerated terms and conditions, and do hereby enter into this contract on this day of 2007. Trust, authorized representative, John W. Doe. Trustee Richard Rowe John Q. Public, trustee, authorized representative contract. Page 4 of 4 ABC Trust, a trust organization in care of 1234 Number Street, Cleveland, Ohio, 54321 123456789 January 8, 2007. Dear Sir/Madam, please accept this letter of introduction from the Board of Trustees of this organization that Richard Rowe has been contracted as authorized representative of this organization to manage this organization's accounts with your institution. Accounts number 123,456,789 and 987,654,321. He has been given all the powers and authority necessary to conduct the business of this organization with your company. Mr. O has held this fiduciary position since January 8, 2007. If you have any questions, you can contact the Board of Trustees at the address shown on the letterhead. Sincerely, Board of Trustees John W. Doe, Trustee John Q. Public, Trustee in witness whereof, I have hereunto subscribed my name and affixed my notarial seal on the day and year last above written. Notary Public. My commission expires : Authorized representative letter of introduction. Bill of sale. Dated, John W. Doe. An individual, referred to as seller, sells, bargains and conveys all of seller's right, title and interest in. See attached Exhibit 1. To ABC Trust, an express trust organization, referred to as buyer. Seller acknowledges receipt of a total of $$_/$100 of gold, U.S., from buyer in full payment of the purchase price of the goods conveyed hereby. Seller warrants that there are no liens or encumbrances on the goods sold, and that seller's title to the goods is clear and merchantable. Seller shall defend buyer from any adverse claims to seller's title to the goods sold. The goods herein are not sold by a merchant in the field. These goods are sold without UCC warranty of any kind, including merchantability and fitness for a particular purpose. Buyer acknowledges examining the goods sold herein. This provision may not be applicable, and legal rights may vary between states. The parties agree to the terms and conditions stated herein. Seller. Buyer, by Richard Rowe, authorized rep. Bill of sale bond we, the Board of Trustees for ABC Trust, an express trust organization, in care of 1234 Number Street, Cleveland, Ohio, acknowledge ABC Trust's indebtedness to Concise Trust, of 9876 Letter Avenue, Cleveland, Ohio, in the amount of $100 of 99% silver, lawful money of the United States, to be paid to Concise Trust, its legal representatives, successors, or assigns on or before January 28, 2007, for which payment we bind ABC Trust and its legal representatives and successors. We, the Board of Trustees, have caused this agreement to be executed at Cleveland, Ohio on this day of 2007. John W. Doe, as Trustee John Q. Public, as trustee and not personally. State of SS, County of on this day of 2007, before me, a notary public, came John W. Doe and John Q. Public, Board of Trustees, and acknowledged the signing thereof to be his voluntary act and deed, and in the capacity stated in testimony whereof, I hereunto subscribe my name and affix my notarial seal on the day and date aforesaid. Notary Public. My commission expires, basic bond Richard Rowe, in care of 1234 Number Street, Cleveland, Ohio, Principal, Concise Trust, an express trust organization, with its principal office located at C. 5678 Number Street, Cleveland, Ohio, and qualified and authorized to act as surety herein. Surety, acknowledge our indebtedness to ABC Trust, of 9876 Letter Avenue, Cleveland, Ohio, obligee, in the sum of $100 of 99% silver, for which payment, well and truly to be made, principal and surety do bind ourselves and our legal representatives and successors. jointly and severally. The condition of the obligation of this bond is that if principal shall indemnify obligee, obligee's legal representatives, successors, and assigns, against any and all loss or damage that may be caused or occasioned by, or that may arise from the actions of principal during the term of his authorized representative contract dated January 8, 2007, and against all liability whatsoever accruing or resulting from such loss or damage, then this obligation shall be void, otherwise it shall remain in full force and effect. Each party to this bond has caused it to be executed at Cleveland, Ohio on this day of 2007. Surety, principal, by, John W. Doe, as trustee Richard Rowe and not personally John Q. Public, as trustee and not personally state of SS, county of on this day of 2007, before me, a notary public, came John W. Doe and John Q. Public on behalf of surety and Jane Public on behalf of, and acknowledged the signing thereof to be his voluntary act and deed, and in the capacity stated in testimony whereof, I hereunto subscribe my name and affix my notarial seal on the day and date aforesaid. Notary public. My commission expires. Indemnity bond. Independent Contractor Agreement ABC Trust, an express trust organization, referred to as contracting party, and Concise Trust, referred to as independent contractor, agree. Independent contractor shall perform the following services for contracting party. Various management services, to be determined on a day-to-day basis. At the following rate of pay, $100 US per day. This agreement shall begin on January 9, 2007 and shall terminate on January 29, 2007 unless earlier terminated. Contracting party may terminate this contract on 14 days' notice to independent contractor for unsatisfactory performance. This is an agreement for independent contracting services. The contracting party provides no benefits such as unemployment insurance, health insurance or workers' compensation insurance to independent contractor. Contracting party is only interested in the results obtained by the independent contractor. Independent contractor shall be responsible for providing all tools and materials required for performance of the tasks agreed to. Independent contractor is responsible for payment of all federal, state and local income taxes if applicable. Contracting parties' property and funds only are liable under this contract. Individual trustees, officers and interest holders are not personally liable. Dated, contracting party, by Richard Rowe, authorized agent independent contractor. Independent contractor agreement. Lease with option to buy. Asset sale agreement. Page 18 of 3. Lease with option to buy. ABC Trust, an express trust organization, referred to as owner, and Jane Public, referred to as lessee, agree. Lessee leases from owner the following described lease property. See Exhibit 1 beginning on January 8, 2007 and ending on January 8, 2008, for a total rental of $1,200, $1,200 and $100 US, to be paid as follows: $100, $100 and $100 per month, in advance, and without demand, and, if taxes are imposed on the rental, these sums shall be paid as additional rental. Lessee has deposited with owner the sum of $100, $100 and $100, as a security deposit. Lessee may not sublet the property without the prior written approval of the owner. Owner shall have the right to inspect the lease property for the purpose of repairs. Lessee shall utilize the lease property in conformity with all applicable rules and regulations. Lessee shall perform regular maintenance, cleaning and care of the lease property at lessee's expense. All repairs of rental property shall be the responsibility of lessee, except that repairs costing in excess of $5,000. And not occasioned by the negligence of the lessee or its family and visitors shall be the responsibility of the owner. The lease property shall be solely utilized for non-commercial purposes. Lessee shall make no alterations to the lease property without the prior written consent of the owner. At the termination of the lease, the property shall become the sole property of the owner. In the final 45 days of the lease, the owner shall be entitled to show the property to potential lessees. At the conclusion of the lease, the lessee shall deliver the property to the owner in as good condition as they were at the commencement of the lease, ordinary wear and tear excepted. This lease shall be subordinate to any mortgages upon the real property, and tenant agrees to execute such estoppel letters, subordination agreements and other materials required by the owner. In the event that the leased property is condemned by lawful authority, or destroyed by reasons other than the negligence of the lessee, the lease shall terminate at the time of condemnation or destruction. Any prepaid rent shall be refunded. In the event that the property is partially destroyed or partially condemned for reasons other than the negligence of the lessee, the rental shall, at the option of the owner, cease, or shall proportionally abate. Should there be any unearned prepaid rent, it shall be refunded. Upon restoration of the property, the full rent shall apply thereafter. The lessee shall have the option, 30 days prior to the expiration of the lease, to renew for a period of 12 months, at a total rental of $1,200, $1,200 and $100 US, payable at the rate of $100, $100 and $100 per month. Owner grants to lessee the exclusive right to an option to buy the property herein for a gross sales price of $10,000, $10,000 and $100 of silver, US, beginning with the term of this lease and expiring on January 8, 2008, or, if the lease is earlier terminated, at that time, until the written exercise of the option, the relationship between the parties shall be solely that of lessor and lessee. This contract represents the entire agreement between the parties, and the same may only be changed in writing. In the event that the owner takes legal action to enforce the agreement, the lessee shall pay all costs of enforcement including reasonable attorney's fees. Dated, _owner, lessee, ABC Trust _ John W. Doe, as trustee and not personally Jane Public _ John Q. Public, as trustee and not personally. Lease with option to buy. Limited power of attorney we, the Board of Trustees of ABC Trust, an express trust organization, hereinafter the principal, in care of 1234 Letter Road, Cleveland, Ohio, herewith appoints Richard Rowe, as its attorney in fact, to act in the place and stead and with the same authority as principal would have to do only the following acts: to open a non-interest-bearing checking account and conduct any and all business regarding deposit accounts, loans, safe deposit box, or other banking business in regard to said account at Colonial Bancorp, of Cleveland, Ohio. This power shall specifically include, but is not limited to, the right to deposit, withdraw, sign checks or drafts, make stop payment orders, and to conduct any banking transactions necessary or possible in regard to the trust's banking relationship with the Colonial Bancorp. This power of attorney shall be in effect from January 8, 2007 to January 8, 2008. ABC Trust Board of Trustees, as principal _ John W. Doe, trustee John Q. Public, trustee acknowledgement state of _SS, county of John W. Doe and John Q. Public. Board of Trustees for ABC Trust personally appeared before me and acknowledged the execution of this limited power of attorney for the purposes set forth therein. Dated, _ Notary Public. Limited power of attorney. Management Agreement ABC Trust, an express trust organization, referred to as manager, and Concise Trust, an express trust organization, referred to as client, agree as follows. Witnesseth, whereas, client is in the business of providing particularly described in paragraph 1 below, which business client wishes to have managed for limited periods of time, and whereas, manager is in the business of providing management services and is willing to provide such services for client upon the terms and conditions hereinafter set forth. Now therefore, in consideration of the foregoing and in consideration of the covenants hereinafter set forth, it is agreed by and between manager and client as follows. 1. Services. Client hereby appoints manager to be the day-by-day manager with respect to any or all of the aforementioned business, property, or articles listed and more particularly described in Exhibit 1 attached. 2. Procedure. Client may transfer all titles, interest, deeds, mortgages, leases or agreements to manager for a period no longer than 10 years. 90. 90 days prior to the expiration date regarding this agreement, the parties may agree to extend this agreement for another 10 years. This agreement may not be extended more than 3 times. 3. Duration and termination, for good cause such as death, sale, or disposition of any or all of the articles listed in paragraph 1, and/or any emergency or crises which may affect the financial status of client. This agreement may be terminated by either party at any time with 60 days prior written notice to the other. In the event written notice of termination is provided, manager shall make changes only with the consent of client. Termination of this agreement shall in no way affect or preclude the consummation of any transaction which was initiated prior to such termination. All properties and articles described in paragraph 1 shall be promptly delivered to client, guardian, heirs, executor, or personal representative after termination, with reasonable delay allowed for recordation of titles, deed mortgages, or leases. 4. Powers, acts, and omissions of the manager. In connection with the rendering of services to client as provided herein, manager acknowledges with this agreement to undertake and effect transactions on behalf of and at the risk of client in such a manner as manager deems advisable with prior notice and approval by client. 5. Managing fees. Client shall pay manager a monthly management fee of $1 of silver, US, per month. This fee is payable upon the acceptance of this agreement and payable each month hereafter. Should this agreement be terminated any time prior to the fee's due date, there shall be no credit allowed for the remaining days nor shall client receive a refund. 6. Further privacy provisions. This agreement and all of the trust business shall be kept protected by the common law privacy rights available in every applicable jurisdiction. The penalty for the release of any information pursuant to the material contained with the context of this agreement or any related material, such person or persons shall be fined or made party of a tort action in the amount of not less than $300,000, $300,000 and no/$100, US. 7. Liability. Client in no way relinquishes ownership of his businesses or properties. Manager may not convert any of the properties held in the trust without client's written consent. Manager may not be held liable for any actions which he may perform in his capacity as manager unless manager has been found by a court of competent jurisdiction to have acted outside his scope of employment, or that he has acted in bad faith in discharging the duties of this agreement. Both parties agree that their management agreement, page 1 of two parties' property and funds only shall be liable under this contract obligation, and that individual trustees, officers and interest holders are not personally liable. 8. Effective date, assignment, governing law. This agreement shall constitute a binding agreement upon its acceptance by manager provided, however, that client may rescind this agreement without penalty within 5 business days after the execution date set forth below. This agreement may not be assigned by either party without the other party's written consent. This agreement shall constitute a contract entered into and governed by the laws of Acton County and shall be binding upon the successors and assignees of the parties thereto. Dated, ____witness client, by Jane Doe. Authorized Rep. __ Witness Manager, by Richard Rowe. Authorized Rep. _ Witness. Management Agreement, page 2 of 2 minutes of annual meeting of the Board of Trustees of ABC Trust in Re. General Business of Year 2006 pursuant to regular notice dated December 10, 2006. The annual meeting of the Board of Trustees of ABC Trust was held at Acton County, Ohio on the first day of January, 2007 at 9:00 a.m. EST. A quorum of trustees attended, as shown by the attached roster. Proxies, if any, were examined and admitted as shown by the attached roster. The meeting was called to order by John Q. Public. By unanimous accord, the following was affirmed and ratified. 1. The first item of business was the review of all books, accounts and records for the previous year. 2. It was resolved and declared by the board that the books, accounts and records balance, and the trust corpus is in proper order. There being no further business to come before this meeting, on motion duly made, seconded, and carried, the meeting is adjourned. Dated this _day of January, 2007. Attest, Board of Trustees _ John W. Doe, Trustee John Q. Public, Trustee. Minutes of Annual Board Meeting. Notice of Meeting of the Board of Trustees of ABC Trust 2, Concise Trust, Beneficiary Receiving Mail care of 9876 Number Avenue, Cleveland, Ohio. Opening bracket 54321 closing bracket. Please take notice that a meeting of the Board of Trustees of ABC Trust will be held at 1234 Letter Road, Cleveland, Ohio on the 2D day of January, 2007 at 9 o'clock a.m. EST. For questions or directions, please contact Richard Rowe at 12345678890. Your attendance is greatly appreciated. Dated this _day of January, 2007 _ John W. Doe, Trustee John Q. Public, Trustee. Notice of Board Meeting. Minutes of Meeting of the Board of Trustees of ABC Trust and Real Estate Assets pursuant to regular notice dated January 1, 2007. A meeting of the Board of Trustees of ABC Trust was held at Acton County, Ohio on the 2D day of January, 2007 at 9 o'clock a.m. EST. A quorum of trustees attended, as shown by the attached roster. Proxies, if any, were examined and admitted as shown by the attached roster. The meeting was called to order by John W. Doe. By unanimous accord, the following was affirmed and ratified. 1. The first item of business is the proposed acceptance of real property into this trust organization. 2. It is resolved and declared by the Board that the Trust shall accept a deed for real property made out to the Trust for property located at 98765 First Street, in the County of Acton, in Ohio State. The legal description of the real estate is as follows. See attached Exhibit 1. 3. The deed shall reflect that the transfer was for $100 of lawful silver and other valuable consideration. 4. It was resolved and declared by the Board that the Trust shall accept a quitclaim deed, grantor deed, or warranty deed for the title transfer of said real property, and list said property on scheduler of the Trust's contract of indenture. 5. The authorized representative is instructed to file said deed with the local county recorder on behalf of this organization, if necessary only. 6. It was resolved and declared by the Board that this day's minutes are to be made available for disclosure upon request of any party challenging the authority of the organization to act in this matter. There being no further business to come before this meeting, on motion duly made, seconded, and carried, the meeting is adjourned. Dated this _day of January, 2007. Attest, Board of Trustees _ John W. Doe, Trustee John Q. Public, Trustee. Minutes of Board Meeting to acquire real property. Minutes of Meeting of the Board of Trustees of ABC Trust and Revocation of beneficial interest pursuant to regular notice dated January 1, 2007. A meeting of the Board of Trustees of ABC Trust was held at Acton County, Ohio on the 2D day of January, 2007 at 9 o'clock a.m. EST. A quorum of trustees attended, as shown by the attached roster. Proxies, if any, were examined and admitted as shown by the attached roster. The meeting was called to order by John Q. Public. By unanimous accord, the following was affirmed and ratified. 1. The first item of business was the proposed revocation of 50 of the 100 beneficial interest units held by Concise Trust. 2. It was resolved and declared by the Board that the said beneficial interest units of Concise Trust is hereby revoked. The default beneficiary shall retain these units until further consideration by the Board. There being no further business to come before this meeting, on motion duly made, seconded, and carried, the meeting is adjourned. Dated this _day of January, 2007. Attest, Board of Trustees _ John W. Doe, Trustee John Q. Public, Trustee. Minutes of Board Meeting to revoke beneficial interest. Non-recourse, non-negotiable promissory note. Concise Trust, referred to herein as maker, promises to pay to ABC Trust, referred to as holder, the sum of $10,000, $10,000 and no/$100 as security. Maker pledges $20 of gold, US. This note shall be due upon demand. This note is non-recourse, and the holder may not seek recourse to any personal assets of the debtor. Maker does not agree to subject any of his personal assets to the payment of this debt. However, the holder of this note may seek to subject any and all security for this debt for foreclosure or other applicable legal or equitable remedies. However, a deficiency, if any, shall not be a personal obligation of the holder. The holder shall be entitled to receive attorney's fees and other costs of collection, provided that the same shall only collected from proceeds from foreclosure or other legal or equitable remedies related to security for this debt. If any, such attorney's fees and collection costs shall not be a personal obligation of the maker, and the maker's personal assets shall not be subject to the payment of these sums. However, any property which is specifically pledged may be subject to foreclosure or other remedy allowed by law. Dated, __maker, Concise Trust by Jane Public, Authorized Officer. Non-Recourse Promissory Note. Notice of Assignment and Instructions for Payment to Frank Rogers, Manager, Colonial Financial Corporation, 1111 Bank Street, Cleveland, Ohio 54321, from ABC Trust to Trust Organization C. 01234 Letter Avenue, Cleveland, Ohio 54321, January 8, 2007. Dear Sir/Madam, please take notice that for value received, the undersigned John W. Doe, referred to hereafter as assigner, has assigned and transferred to ABC Trust, its successors and assigns, assignee, assigner's net wages in order to satisfy the indebtedness of $100,000, together with presently unspecified additional amounts as may be added through additional transfers or as the result of assigner's default, collectively. The assignment amount. Any increase in the assignment amount above the specific amount set forth in the attached assignment shall be deemed effective as of the date of this notice. Please contact Richard Rowe, attorney in fact for ABC Trust at 12345678890 to obtain the most current assignment amount. Payment of the assignment amount shall be made directly to ABC Trust at the above address, or as otherwise instructed in writing by the trust. No payment shall be made to assigner unless and until the assignment amount is paid in full. A receipt signed by ABC Trust shall have the same force and effect as a receipt signed by assigner personally. John W. Doe Assigner. Notice of Assignment and Instructions for Payment. Notice of Private Sale of Collateral. Date, January 8, 2007 to Colonial Bancorp, 5678 Number Street, Cleveland, Ohio 54321. Pursuant to the Uniform Commercial Code, you are notified that on January 13, 2007, the undersigned as secured party in possession shall sell at private sale the following collateral. See attached Exhibit 1. Said collateral shall be sold to Esquire and Esquire, LLC. Buyer, for the amount of $9,000. You will be held liable for any deficiency resulting from said sale. You may redeem this collateral by paying the amount due plus accrued costs of foreclosure at any time prior to the time of sale. You shall have no right to redeem the property after the sale. The balance due as of this date, including accrued costs, is $11,467.19. All payments must be by certified or bank check, or postal money order. Richard Rowe, attorney in fact for ABC Trust, secured party in care of 1234 Letter Road, Cleveland, Ohio, 54321. Certified mail #01234567891011112. Notice of Private Sale of Collateral. Offer to buy automobile. 2. John W. Doe C. 01234 Number Road, Cleveland, Ohio. ABC Trust, an express trust organization, offers to buy the following automobile. Make, model, year, body style, vehicle identification number, For the following price, $1 of gold, $1 and no/$100, US, plus any applicable sales tax and the following described additional charges. Tax, title, and tag, totaling $75, $75 and no/$100, upon the following terms. one lump sum payment. This offer shall expire unless accepted by January 10, 2007 at 12:00 a.m. EST. Dated, _ABC Trust, by Richard Rowe, Authorized Rep. Accepted by, John W. Doe, an individual. Offer to buy automobile. Proposal to exchange property. 2. John W. Doe and John Q. Public Board of Trustees of ABC Trust, an express trust organization in care of 1234 Letter Avenue, Cleveland, Ohio. From Jane Doe, Exchanger C. 05678 Number Road, Cleveland, Ohio. Re. Exchange of coin collection for capital interest in the trust organization. January 8, 2007. Dear Sirs, after considering the benefit of transferring property into your organization, I have decided that an exchange of my property for capital interest holds a promise of attractive future benefits. This offer is, therefore, submitted for your consideration. I hereby propose to exchange the property described below for capital interest. Further, it is understood that such an exchange would be neither a gift, nor a sale, but an exchange. If this meets with your approval, please reply. Description of property. See attached Exhibit 1. Existing liens against the property, if any, none. Please respond at your earliest convenience. Thank you. Cordially, Jane Doe, Exchanger.